You ready? All right, good morning, everybody. We're going to go ahead and start taking open announcements for the 9 a.m. docket. If you are appearing via Zoom, I would ask that you please keep your microphone muted until it's your turn to testify or talk. Also, there's a little button there on your phone or on the computer that says stop video. If you don't stop it, we can see what you're doing. And although it might be funny and entertaining, if you wouldn't do it in the courtroom, please don't do it on Zoom. Just stop your video until it's your turn. For those in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. I am not going to direct you on how to make your own personal health decision. However, the inmates I do require to wear a mask because they have to be here. And so with that, I'll go ahead and take open announcements on the 9 a.m. docket. Mr. Stevens?
Judge, I have George Smith. He's out in the hallway. I didn't see him on the docket though. Maybe I overlooked it, but he's here.
He's
I'm here.
Can I see the docket sheet on here?
You're here, Judge.
Yeah, that's fine. All right, this is cause number CR 19-0767-392, the state of Texas versus George Smith. And this is set for status today. Where are we at?
Judge, we have not reached an agreement yet on this case. We do have an offer. I think it's 8 TDC. I think this might be our first status. If you would
There's
allow,
only
I'd
one
like to
status.
reset it for another status if you'd let us.
I mean, typically there's only one.
I know.
Sure.
But
I'm open to negotiations with Mr. Stevens.
I mean, how far apart is Mr. Smith? You told me he was ill.
Yes, sir. This one I talked to you about the chambers.
Mr. Smith, they say you couldn't take a COVID test because you were too ill. I don't understand.
No. They just took the thing at my nose. I don't know what it was. I was peeking so much that I don't know what my boss was there with me.
I don't understand.
I
what you're
misunderstood.
saying.
I thought you said you couldn't take the
Yeah,
COVID
no.
test because you were.
Oh, okay. Well, then, and so what I'm going to do is I'll reset status to June 3rd at 1:30. And did you get a result from that COVID test?
If I did, sir, I didn't hear him. I was sick. My girlfriend just got the test results. I don't think I had COVID. No, it's an upper respiratory infection.
Okay. Well, I'm going to order you to take a drug test today. You're going to go take the test. When you're done, come back
Right.
in the courtroom and we'll go over the results together.
I misunderstood him, I guess. I thought he said he couldn't take the test. I'll talk.
You know, check this temperature. That's fine. If he would have had COVID, they would have told him. You would think. Who else you got, Bill?
Savannah Boykin.
I'm sorry?
Savannah Boykin. I think she might be on the first page.
I got it. Miss Boykin.
Maybe I'll call her.
Can they hear out there in the hallway? Should be able to. I was hoping for a yes or a no, but I got a should be able to. He doesn't know the answer. All right, this is cause number CR 20-0644-392, the state of Texas versus Savannah Boykin, and that is set for pretrial. Any pretrial from the state?
Yes, Your Honor. State offers in the our standard motion for pretrial.
No
which is
objection.
our list of experts. Who comes.
All right.
No objection, Judge.
Do we have it?
Is that tendered over?
Granted. And any on behalf of Ms. Boykin?
No former pretrial matter, Your Honor.
All right, well, then the court deems pretrial is held. And do we have an offer in this case?
There are two offers, Your Honor.
Yes, Judge, I have a probation offer and a time offer.
Okay, can I see the docket sheet? All right, then the court deems pretrial is held. Ms. Boykin, your next court date is June the 3rd at 1:30 for status. And typically that's your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. And so just abide by the conditions of your bond, stay in touch with your bondsman and your attorney, and we'll see you back in June. And you're free to go as soon as you receive your reset notice.
I think that's it for me, Judge. Come on, drug test guy.
HDMI, it should. Mr. Schmidt.
Your Honor, page one, and slide on Mr. Weiner. Agreement. John and Mary Bearden, co-defendants. If you want to hear them together, they're both on page one, Judge. Two and three on the docket we're looking at.
Oh, that's a different one, yes. I'll come on up. Have the Beardens come up anyway, we'll find them.
Page 4.
In 7. All right, these are cause numbers CR 20-0630 and 0631-392, styled State of Texas versus Mary Bearden, both cases. And then also cause numbers CR 20-0628 and 29-392, both styled State of Texas versus John Bearden. And this is set for pretrial today.
Judge, we also we've tendered over our standard motion for pretrial, which is the list of experts by the defense.
We have no objection.
Same, Your Honor.
Granted as to both cases, or as to all 4 cases for both defendants, and any on behalf of the defendants.
We have no contested pretrial matters before this time, Judge.
Nor do we, Your Honor.
All right, well then, court deems pretrial is held. Are y'all close to working this out?
I think we're close, getting closer by the day.
Is there an offer?
There's a few things floating out there getting created.
Maybe a few things that have to be done, and then there's a
No,
dismissal?
no, actually, there's just maybe a few potential alternatives.
Okay. All right, well then, for both the Beardens, then the court deems pretrial is held. Both of you, your next court date is June the 3rd at 1:30 for status, and typically that's the last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. So as soon as y'all receive your reset notices, you're free to go.
Thank you, Judge.
Thank you.
Okay, thanks.
Just one of those cases. Oh, one of the facts. Thank you. Hey, Brian, is that Mary Shira? Okay.
Yep.
Yeah, you did until you said it. I didn't.
My other case, Judge, is on page, well, supposedly page 3, Robert Hocutt. It's probably on the very last page from Weiner.
Yeah, I think they kinda did adopt it. Cut. It says cause number CR 20-0713-392, the state of Texas versus Robert Hocutt, set for pretrial. Any pretrial from the state?
Just standard order for discovery.
We have no objection to the state standard request for disclosure
Granted.
experts.
And on behalf of Mr. Hocutt,
We have no contested pretrial motions for the court this time.
all right, Mr. Hocutt, then, Wilfer, is there an offer?
Yes, Your Honor, it's 15 years.
15 years?
We've also discussed a potential cap in a plea open situation.
We have.
All right, well then, Mr. Hocutt, court deems pretrial is held. Your next court date is June the 3rd at 1:30 for status, and that's typically the last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. All right, so as soon as you receive your recent notice, sir, you're free to go. We'll see you in June.
Yes, sir.
Thank you, Judge. Maybe excused.
Yes, ma'am.
That's all I have. Maybe excused.
Sure.
Thanks.
Green.
Stage one, Judge Michael Emery.
Emery, come on up. This is cause number CV 21-0183-392, ex parte Michael Lynn Emery, set today on a writ seeking bond reduction. Is the applicant ready?
We're ready, Judge, and just to cut to the chase, Mr. Strong and I have an
Okay.
agreement for a $1,500 surety bond. And I just need to submit an order to the court.
We're in
No.
agreement with that, Judge.
And
I think you submitted the order. It had a 1,500 PR on there. If we could just scratch out the PR and make it a surety.
I'll look in the file. I'm gonna be here for a minute. If not, I'll get it set over here. I can't,
You got it, Sandy?
I don't think I did.
Okay. Yeah, just submit it to me. You can have a seat and I'll sign it, Mr. Emery.
Thank you, Judge.
Yes, sir.
Now, Holly Goff on page 2.
Holly Goff. I see
Yeah,
the right.
but I need to talk to him one more time.
This is cause number CR 20-0447-392, the state of Texas versus Holly Goff, and set for pretrial. Any pretrial from the state?
Yes, Your Honor. Standard motion for discovery listing the experts from the defense.
No objections, Judge.
Right, granted, and on behalf of Ms. Goff.
None, Your Honor.
All right, well, then the court grants pretrial is held. Is there an offer?
There's 2 authors at this time, probation and one's for time.
Okay. All right, then the court needs pretrial is held. Ms. Goff, your next court date is June the 3rd at 1:30 for status, and typically that's your last day to resolve your case by plea bargain, or it ends up on the trial docket. However, I am ordering you to take a drug test today. You're going to go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together. So don't leave until we talk. Ms. Fallhaber, or is that it?
I'm working on my.
Ms. Fallhaber.
Got Daryl Menifee on page 1.
Mr. Menifee, come on up. These are cause numbers CR 20-0694 and 695-392, both style the state of Texas versus Daryl Menifee, and both set for pretrial. Any pretrial from the state?
Yes, Your Honor. Standard motion for discovery.
No objection.
Granted, and on behalf of Mr. Menifee.
Your Honor, I believe we also carried discovery status because of the discovery status setting. I had announced that I believe that there should have been a 911 call included in the discovery. I have talked with a representative of the state, and they have again informed me that they don't have one, but I do believe that this was a call. And so
We just dealt with this issue in another case where the call was not on the system. Is that, what's the deal? Why can't we get a 911 call?
I thought this was a patrol case, not a 911 call. I'll have to look into it. So
it was unclear from the offense report because it says they were responding to a disturbance.
Is it Athens PD?
it is.
I mean, it's just easy enough to call and say, is there a
I'm being told it isn't assault. On the assault public servant, there was no 911 call. So
Can I see the probable cause affidavit? We just solve it. Let's just look at it right now. Are they, it's probably the same one for each case. It's just duplicated. We're gonna figure this out right now, Mr. Menifee.
It says they responded to New Haven Apartments in reference to subjects not following an order. So what were they responding to?
It is the New Haven Apartments. It does, they do have quite a bit of police activity that goes on there.
It's the language in the offense report about responding.
Could have been a radio call.
What's that?
Could have been a radio call if they were
I don't
already
have
there.
that either.
And you don't either. So that's why we need to find out.
Right.
I got you.
It's just when the beginning of the discussion is a response.
I understand. You kind of want to know what they're responding to. Do y'all have the probable cause affidavit? Should be in the offense report. Usually in the back. I don't, and I hate to belabor it, but I don't want to come back on another hearing and we
Sure.
still don't know whether there's a 911.
I feel more comfortable talking to Adam before I make any comments this morning.
Well, this says that they were responding to a violation of the emergency management plan that the manager of the New Haven apartment complex had called saying several people were congregating that didn't live there. So
Let me look.
it either came in through the 911 side or the regular. If it came in through the other side, you're not going to have a recording. So here's what I'm gonna do. So you have the date and time, it'd be easy enough to see if there's a 911 call. What I'm gonna do, Mr. Menifee, is I'm going to set this again for pretrial on June the 3rd at 1:30. And hopefully we'll have that answered by then. So I'm just gonna reset pretrial to June 3rd at 1:30. All right, sir. Is that all right with you?
Yes.
All right, and as soon as you receive that reset notice, sir, you can have a seat. You want to make a sign and put it on the,
Great copy. You got it. I'll talk to you soon.
see you in June, Mr. Menifee. You can have a seat. Yes, ma'am.
Robert Lima.
Robert Lima. This is cause number CR 20-0552-392, the state of Texas versus Robert Lima, set for status.
Your Honor, I don't believe we're going to be able to work this case out. So we just want to set it for trial.
Is there an offer?
There's
There is-
currently no offer.
There was an offer that was conveyed last week when I went to the DA's office and spoke with Mr. Strawn. I conveyed that offer to my client who asked me to make a counter offer. And I was informed, I believe yesterday, that the counter was treated as a rejection and that there would be no offer.
It was pretty far off. from the
What was the
offer.
original offer?
The original offer was 30. I came down to 15 on a 25 to life, and he's offered 2 and 5. So,
Well, then how
However,
long has he been in jail? Y'all are way far apart.
He's been in jail for a while, but I would like to inform the court, however, that last week when I chatted with Mr. Lima, he informed me that in the past, Your Honor has prosecuted him, and as such, he's requested that I file a motion to recuse. And I looked it up, and your name does appear on the online.
What year?
It was, I think, 2012.
Me personally or my office?
His recollection is you personally.
Okay.
Your Honor, we'd ask that that's a stipulation to the prior.
I'm sorry?
We'd ask that that's a stipulation to the prior, if he's asking to recuse himself on that prior.
Well, once he asked to recuse, once he
Sure.
asked that, I can't do another thing.
I
on
just
the
want that
case.
on the record.
I need, if I approve it, then it goes to Judge Charles and they appoint somebody else. If I deny it, then he can have a hearing. I mean, the name sounds familiar, but that might be because of being in court here. I mean, I don't recall.
Sure, no, I understand. But as you can imagine, he would remember.
I understand. So one case, it was who? Barry Spencer? Well, that would have been pre-2009. Could even have been Sherry.
Your Honor, that you were the DA at the time, but it was Mark Hall and Jenny Huckle showed up. Judgment, so
So the current DA, Mark Hall. And what was the case?
that was the tribunal. Oh, that's that. That's an act assault.
The 2015 case was pled on November 30th of 2015. And it looks like Mr. Cox's signature is on the Cox, the prosecutor.
Well, then, if you want to put it in writing,
Yes, sir.
I think you have to put those in writing anyway. I'm not sure, but it'd be better if it was in writing. So if you want to submit a motion, and I'll go back and look at some of them, but I don't recall. And I'll just rule unless y'all want a hearing.
Yes, sir.
Okay. All right, well then, the court deems, well, I can't do anything if you're going to file that. So I'm just going to reset it right now for June 3rd for a status, and then we'll go from there.
Yes, sir.
Okay. All right, Mr. Lehman, as soon as you have that reset notice, you can have a seat, sir. You know, you're in a small county when they start listing names and every one of them are in the courtroom. Some. Incestuous.
Got it.
names to
That's
live.
all I have this morning. May I be excused?
Yes, ma'am.
All right. Thank you.
Ms. Moore.
Starting on page 3, leave out the blue.
Mr. LeBlue, come on up. Yeah, he's got a. I'm going to start off with the one with the arraignment, and then we'll move into the other two.
Well, I
Are you not appointed on that?
was not appointed on that case. Mr. LeBlue has informed me he's hired Mr. Head to represent him. He has some new charges that he's was arrested on about 10 days ago that are those cases. Probably how many felonies? 3? I think 3 felonies.
I'm familiar
I know
with
I've
him.
been appointed. I went and checked because we kind of had a conversation about what Mr. Head was being hired on. I'm only appointed on the ones that are on page 3 and 4 and some other unindicted. I haven't been appointed on this CR 21-0391-392. And he also has a possession case that I don't think he has an attorney on from March of 21.
Well, I mean, then that would mean question whether he's still indigent or not. If he's hiring a lawyer and he's got a court-appointed one on another case.
I recognize that. I didn't realize, I didn't even know
No, I
that his
understand.
arraignment was set today because I wasn't on that, so I didn't get any notice that was set. I didn't realize that it was set. So I know Mr. Head specifically indicated he was not retained on that
Not
case.
good
And I
for-
think Mr.
Sure,
LeBlue
yes,
would
sir.
be asking for court-appointed counsel.
I quoted Mr. LeBlue a fee to try to handle everything. Obviously, there's numerous different dates of alleged
Right.
offenses. And then I also quoted him a fee if he just wanted me to take this latest situation. His family is attempting to come up with the money on the latest situation. If, obviously, if they're able to hire me on everything, I'll take over everything. But at this point in time, they haven't even been able to come up with the full amount on just the new case.
Okay.
So,
Well, then if y'all don't mind, I'll just drive forward on these other two, and then on the arraignment, I'd like at least arraigning, and so Ms. Moore, do you mind standing in at least for the arraignment?
Absolutely not. That is no
Um,
problem. He
Mr.
actually
LeBlue, do you
has-
have a problem with that? That way we can at least get you
No, sir.
arraigned today?
Yeah, I don't have a problem with it.
Okay, so let's do this then. I'm gonna call the arraignment case first. CR 21-0391-392, the state of Texas versus Levi LeBlue, and Ms. Moore standing in for arraignment.
Your Honor, this is Levi Gad LeBlue. His name's spelled correctly in the indictment. He understands what he's charged with is set forth in the indictment. And enter a plea of not guilty for purposes of arraignment and not true to the enhancement paragraphs.
All right, Mr. LeBlue, the court notes your plea of not guilty and not true in the indictment. And let's see, what are his next two court dates?
Let's do July 7th at 1:30 for discovery status, and then August 4th at
All right, so Mr. LeBlue, what I'm gonna do is you just heard Kevin, if you didn't, it's July 7th at 1:30 for discovery status, and then August the 4th at 1:30 for pretrial. If for some reason you can't come up with that money because you're still indigent or your family can't, I'm gonna appoint Ms. Moore to this new case that you're already indicted on.
And he did indicate to me that he didn't, I can't say this, that he didn't think he would have funds to hire Mr. Head except for the new thing.
Okay,
So,
well, we'll see kind of where it pans out by July.
Yes, sir.
And when you come back. And so now let's move on to these two other cases, CR 20-0387 and 0388-392. Both styled the state of Texas versus Levi LeBlue and both set for status.
and Your Honor, he has two cases on the
Oh,
next page
sorry.
as well. I thought these were all moved for pretrial today. I would be asking to move them all to that July 7th, I think he said, day, in light
Kind of run
of
them all together.
his new,
All right, let's do that then. CR 20-0706 and 0707-392 also styled the state of Texas versus Levi LeBlue. Those are set for pretrial. I'm just going to stop everything, move all of these cases to that July 7th at 1:30, and I'll just set those 387, 388, 706, and 707 for pretrial.
Thank you, Judge.
Got all that, Mr. LeBlue?
I think so.
I'm going to give him his notice, Your Honor. Thank you. That's all I have this morning.
And Mr. LeBlue, as soon as you receive that reset, notice you can have a seat. Mr. Head.
Jeremy Jackson.
All right, this is cause number CR 20-0650-392, the state of Texas versus Jeremy Jackson, set for pretrial. Any pretrial from the state?
Yes, Your Honor. Standard motion for discovery to list experts by the defendants.
No objection, Your Honor.
Granted, and on behalf of Mr. Jackson.
Your Honor, I've reviewed the written discovery. I've not received any audio video discovery yet. And I would assume that there is a video camera. There's a marked patrol car that makes a stop. I think there probably will be a need for a motion to suppress if we could carry that forward to the status conference.
See if we can't figure out where Mr. Strong, you know anything about a in-car video?
I'll have to look. I was just asking Ms. Hughes, and she said that, I guess you were just appointed.
Well, I actually was retained recently to step in for appointed counsel. So the state hasn't had a lot of time to get that to me, and I'll check with the prior appointed counsel to see if they have a copy of it. If they do, I'll go ahead and get that from them as well.
Okay, well, here's what I'll do. I'm just gonna just pause this. I'll set it for discovery status on June the 3rd at 1:30.
Thank you, Judge.
I'm just gonna back it up, Mr. Jackson, to allow Mr. Head to get all the discovery, and then Once he looks at it, he may or may not need to file pretrial motions.
Yes, sir.
All right, that all right with you?
Yes, sir.
Well, then we'll see you on June 3rd at 1:30 for discovery status.
Thank you. That's all I have.
Yes, sir. Thank you. Mr. Green.
This dog finished her drug test and they said they told her it was negative, but I guess it hadn't made it over here. So, Joshua Parnell.
Joshua Parnell, come on up, sir. Y'all have an agreement?
We don't have an agreement on that case, Judge.
All right, this is CV 21-0167-392 ex parte Joshua Mark Parnell set today for a writ seeking bond reduction. Is the applicant ready?
We're ready, Your Honor.
And on behalf of the state,
State's ready, Your Honor.
and are we going to hear testimony from your client, Mr. Green, for the limited purpose of bail?
We are, Your Honor.
All right, sir, if you could raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand and lower that mask too, if you would.
Yep.
All right, Mr. Green.
Mr. Parnell, state your full name, please.
Joshua Mark Parnell.
And Mr. Parnell, how old are you?
I am 32 years old.
And you're currently in the Henderson County Jail, is that right?
Yes, sir.
And you have been there, how long?
For almost 60 days.
You're charged with an aggravated assault with a deadly weapon case, is that right?
Yes, sir.
And the bond in that case is $10,000.
Yes, sir.
And you're also charged with unlawful possession of a firearm by a felon.
Yes, sir.
And the bond in that case is also $10,000.
Yes, sir.
Now, related to that same incident, but not part of the writ for this seeking bail reduction, you are also charged with 2 misdemeanor offenses as well, correct?
Yes.
And that was out of that same incident.
Yeah.
And you and I have talked, and I explained to you that because those are misdemeanors and you've been held over 30 days, that you would be entitled to PR bonds in those cases.
Yes, sir.
But we have not pursued those yet because you're still being held on these.
Yes, sir.
Do you have the means to make either one of those $10,000 bonds?
Yes, I do.
And what means would that be?
Family and side work, we're looking for employment.
And when I say the means to make those $10,000 bonds, you have the means to make a bond, but just not at the amount of $10,000. Is that a
Yes.
fair statement?
Yes, sir.
And you're going to have to rely on family and friends to come up with the funds to make,
Yeah.
to raise the money to hire a surety to make those bonds for you. And so you're asking Judge McKee to reduce those bonds to a lower amount so that you don't have to come up with as much money.
Yeah.
And so when you were arrested, where were you living, Mr. Parnell?
I was living in 7 Points,
And who were you?
or it's a Waterport. Or do I just say,
Well, just say, what is the address?
oh, that is Blanket Lane?
Okay, and in 7 Points?
Yeah.
And who were you living there with?
My father,
And what's his name?
Mark?
Parnell?
Yes, sir.
And how long had you been living there?
For almost 4 months.
And your father is, as you understand it, from the allegations, the alleged victim in the aggravated assault
Yes,
case.
yes, sir.
And it's, you have been served with papers for a 60-day emergency protective order, correct?
Yes, sir.
It's your belief that once that 60 days expires, that you and your father will be able to communicate, and you don't think that that's going to be a problem with your father communicating with you?
No, sir.
If you get out, where will you go?
After the 60 days, I most likely would be able to be home again.
You think your father would be okay with that?
Yeah, for the moment to figure things out. So.
Yeah, I can hear him. I'm having a hard time.
Oh, I would be able to go back to my house and we could figure things out.
So is there an amount of bond that you feel like that you would be able to raise the money to make the reduction on those $10,000 bonds?
I mean, over time, I could make the money
but I would like it possible if you guys could lower it as low as you could.
So you think you can make two $2,500 bonds?
Yeah.
Okay. And Mr. Parnell, you do have some felony convictions, correct?
Yeah.
And those were where?
San Diego, California.
And those were felonies that you received probation for and that you successfully completed.
Yes, and also I either did that or did my time for the
Okay, in the state penitentiary or in a county jail?
county jail.
Okay. All right. And how long ago was that? The most recent one?
2019.
If Judge McKee lowers your bond and orders you to comply with conditions of release, such as checking in with a pretrial release officer, taking urine tests, those kind of things, you certainly be willing to do that as well.
Yes, sir.
I pass the word to Sean.
Thank you, Your Honor. Mr. Parnell, actually, you're under a 60-day emergency protective order with your father. Is that correct?
Yes.
So you've not been in contact with him, have you?
No, I have not.
So you don't know if he wants you home or not, do you?
No, but I had family, my sister mail me a letter.
Okay, but as far as your father, you made a statement saying that you communicate and you could go home, but you don't know that.
I don't know that for a fact.
Okay. Do you have any other place to stay?
I could call my sister and she could possibly help me out. So,
But you haven't talked to your sister.
no, I just gotten a letter from her. That's all.
Okay. Where does your sister live?
Right now she's currently visiting my parents. So,
Okay, where's she visiting from?
she's visiting from California.
Okay. So you've been here in Texas for 4 months, is that correct?
Yes.
Okay. Now, where were you employed prior to coming here, or have you been employed?
Have I been employed? Not here, but I have been employed before.
And where was that?
I've worked at the 99-cent store. I worked, did some hard labor as a termite tent guy.
When was that?
That was a while ago.
What's a while ago?
2011, 2000.
Okay. You have a vehicle?
I do not.
No further questions, Your Honor.
Thank you.
Judge, we just asked for two $2,500 surety bonds.
Let's see the probable cause affidavit.
Yes, Your Honor.
Mr. Green, do you have a copy of that?
I don't, Judge.
Is this, do they say the same things, basically?
They're on the two different, one's the felon possession of firearm, one's the aggravated assault.
But it's probably the same thing, just, they say the same thing.
A little bit different, but yes, sir. They're not identical, no, sir.
Well, I'm gonna let Mr. Green look at them before I do.
Yes, Your Honor.
'Cause it wouldn't be fair that he doesn't know what I'm looking at. And while you're looking at that, Ms. Goff, you're free to go. We'll see you in June. Only took me a couple months to come up with it. Yeah, I don't know. That's not.
Thank you, Judge.
I still want to look at them before you have a chance.
Yes, sir. Thank you.
You're welcome. Anything else? All right, well then respectfully, the request to reduce bond is denied and bond will remain at $10,000 surety bond on each of the cases.
Yes, sir. Thank you, Judge.
Yes, sir.
George Smith, that you ordered to take the drug test that was ill. He's out there thrown up in the lobby. They went and got him a bucket. He is really ill. He can't take his drug test yet because he's dehydrated.
Okay.
And I'm not, I mean, don't know what to do. So anyway, I'm just letting you know, Judge.
Threw up in the lobby?
Well, they got him a bucket at the probation department, then he threw up in the bucket.
Okay. Can we test the bucket?
You
don't wanna do that? Nothing. All right, here's what I'm gonna do then. I'm gonna, what's today? Wednesday? When's the next time? We have court tomorrow, don't we? And Friday. That's right. What time? All right, I'm gonna order him to appear at 9 a.m. Friday morning for a drug test. Are you here?
No, sir, not Friday morning.
When's the next time Bill's here?
I'm here tomorrow.
Afternoon?
I mean the afternoon and the morning, Judge both.
I'm gonna order him to appear at 1:30 tomorrow afternoon. $1:30 tomorrow afternoon. Is he?
He's out, you want me to bring him in so you can order?
Just
him,
bring
bring
him
back,
right
or-
there, right at the entrance. 'Cause if he throws up, I'm not gonna throw up, but other people might start. It's contagious. Mr. Smith, I understand you're sick. I want you back tomorrow at 1. I'm ordering you back tomorrow at 1:30 to take a drug test. Make sure you're hydrated and maybe whatever you got will be gone.
Yes, sir.
1:30 tomorrow. That is May the 6th, 1:30 here in this courtroom.
Yes, sir.
All right. Yes, sir. Morning.
Got 3 M's, Matthews, there, and Louisville.
Which page? Gotcha. Marty Matthews, come on up. This is cause number CR 20-0645-392, the state of Texas versus Marty Matthews, set for pretrial. Any pretrial from the state?
Yes, Your Honor. Standard motion for this.
No
Any
objection.
objection? Granted, and on behalf of Mr. Matthews.
No pretrial motions, sir.
All right, and do we have an offer?
We do, Your Honor. It's 12 years TBC.
All right, well, then, Mr. Matthews, the court deems pretrial is held. Your next court date is status, and that is on June the 3rd at 1:30. And that is typically your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. Okay, sir. As soon as you receive that reset notice, you're free to have a seat.
Thank you, Judge.
Mooneyham,
Yes. Judge, I got an email from her yesterday. She went to the doctor. She had a fever. I didn't know they're doing this now, but apparently if you have a fever, they can give you an emergency dose of Moderna. So she got an emergency, anyway, she has a fever. She's not here today. And she's being tested for COVID. I don't have the COVID result.
I see her right there.
Yeah, I just sent her the link.
Is this the second time Miss Mooneyham has not shown up for court because she is afraid of COVID or something?
I don't.
Well, let me call it. This is CR 20. Miss Mooneyham, can you hear me? Oh. Ms. Mooneyham, can you hear me?
Yes, sir. Yes, sir.
I'm going to call your case CR 20-0505-392, the state of Texas versus Amy Mooneyham. And Mr. Steele, so she had a fever and then got her first.
Apparently, she has a fever and she went and saw the doctor and they gave her first dose of Moderna, an emergency. They can do an emergency dose if somebody has a fever. That's my understanding.
I didn't give it to anybody. They want to give it to kids now, which to me is ridiculous, but they want to give it to everybody now. I think
Yes.
there's plenty of doses available.
And she has a fever. I didn't think we would want her in the courthouse today.
I mean, typically if somebody's sick or maybe they just call in and clear it with Kevin so we know that they would have tested her for a fever right out here. So you got notice of this? A few minutes ago.
Yeah, I didn't, yeah, Judge, I didn't.
Can I see the docket sheet? Yeah, it appears on April the 7th, she showed up and tested positive for methamphetamine.
We sent those drug test results off because she was on medication, Judge.
And they're still pending?
Yes, sir.
Well, those are still pending, so I hate this COVID stuff. And which doctor did she go to?
Amy, can you hear me?
I mean, so I don't have any proof of it. You would think somebody's due in felony court, they would call their lawyer and offer to fax them a doctor's note or email them.
She went, yeah, Judge, I asked her to email this to me, but this is all she sent me. East.
I can't hear him. Can't hear him.
Okay, well, it does show she got her first shot on yesterday. All right, Ms. Mooneyham, here's what I'm gonna do. State object to me moving this. We already have a pending lab out there
I
anyway.
was
We'll
waiting to
see.
see that confirmation.
All right, Ms. Mooneyham, then for the record, Mr. Steele has showed me a copy of your COVID vaccination card. And it does show for the record that you received the Moderna shot yesterday. And so I'm going to excuse you for today, but I will see you on June the 3rd at 1:30. You understand, for status?
Yes, sir.
That'll be before her second dose. All right, we'll see you then, Ms. Mooneyham. You're free to log off.
Thank you, Judge.
Yeah, back up. I saw her name pop in. That's why I called her McNair.
We're 2 out of 3. We got 2 out of 3 done, Judge. Yes, McNair, Judge.
All right. These are cause numbers CR 20-0319 and 0664-392. And both of these are styled the state of Texas versus Matthew McNair. And let's see, is there any more? Nope. The 0664 case is set for pretrial, any pretrial from the state.
Yes, Your Honor, our standard motion for discovery. It looks like we have it in the other cause as well. I don't know if we turn that over or not.
No objection.
All right, then I'll sign it for each. And then any pretrial on any of the cases?
Not at this time, Your Honor.
Okay. All right, well, then the court deems pretrial is held. And what I'm going to do is I'm going to set these both for status, so they're running together on June the 3rd at 1:30.
Thank you.
Yes, sir, Judge.
Do we have an offer out there to wrap them both up?
There is, Your Honor. The current offer is 30 years on Mandel and TIC, the unlawful possession.
Okay. All right, then, Mr. McNair, then we'll run them both together. Status is on June the 3rd at 1:30, and typically that's your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket.
Thank you, Judge.
Yes, sir.
May I be excused?
Yes, sir. Good to see you.
Have a good day.
Yes, sir. Kind of a weird day. Feels like a Monday. Doesn't it? Have I gone through the docket and called all the names yet? Mr. Gonzalez. He's got. Make sure everybody's here. Ricky Hooper. Kelly Snorgrass. Gotcha. It's okay. I'm not calling you up yet. Just make, are you ready for him? Okay, come on up then, Mr. Snorgrass. I'm just calling through the docket. This is CR 20-0619-392, the state of Texas versus Kelly Snorgrass. And this is set for pretrial today. Y'all have something worked out?
We do, Your Honor. We
Okay.
have
Mr. Snorgrass, you need to stand over here and let the clerk swear you before we get started. When, just now? Okay. I'm ready to take it down. I know. They don't like us doing stuff. They don't like us climbing ladders. They don't like us pulling wire. I think we're pretty handy folks. I didn't bring you that paint spray. I haven't even got to it. I called it. Didn't I? All right, set for pretrial. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor. State's ready.
And Mr. Harrington, on behalf of Mr. Snorgrass.
ready, Your Honor.
All right, sir, is your name Kelly Don Snorgrass? And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. That's sir, you can lower your hand. Mr. Snorgrass, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir, I am.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir, I do.
And Mr. Snorgrass, have you ever been treated for any mental health or emotional issues?
Yes, sir.
You understand what's going on in here?
Yes, sir.
And Mr. Harrington, do you believe your client is competent?
Yes, sir.
Court finds he is competent. Mr. Snorgrass, I know that we have already arraigned you on this case. However, would you like for the prosecutor to read the indictment out loud here in the courtroom?
I've read it.
You've read it. Do you need them to read it?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. However, it's my understanding that you have this deal worked out with the state whereby that you would plead guilty in exchange for them reducing this to a state jail felony, which is a lesser included of the indicted charge. A state jail felony carries a punishment range of not less than 180 days, nor more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Further, it's my understanding that based upon that plea bargain, they would recommend that the court punish this as a Class A misdemeanor under 1244 of our penal code. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine up to $4,000. Do you understand all those punishment ranges in the plea bargain?
Thank you, Judge. As already stated, the state has agreed to lesser included of the indicted offense, which is possession of controlled substance PG1 less than 1 gram. Further, under 1244A, the agreement is for 85 days county jail with credit for 85 days, plus fine, court cost, and $180 in restitution to DPS.
Is that your understanding of the plea bargain? Is that your understanding, Mr. Harrington?
It is, Your Honor.
Mr. Snorgrass, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over that with Mr. Harrington, both the front and the back? And did you sign the front and the back? Any questions about it? The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that and sign the second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Harrington? Well, if you read and went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to enter into this plea bargain? Then I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the state jail felony possession of a controlled substance? Are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? I'll hear the evidence.
Thank you, Judge. The state offers in the evidence 3 exhibits. We have state's exhibit number 1, the offense report present. Our printer just ran out of ink. They are printing exhibit 2 and 3, which have been provided to the defense. Exhibit 2 would be the Morton compliance and exhibit 3 would be our lab report. So
No objection, all three.
All right, well then, all 3 are admitted and states 2 and 3, if you just get them to
they're on
me.
their way.
All right, and anything else from the state?
Nothing further resting close, and here they are.
Right. And for the record, states 2 and 3 are being produced to the court now. And anything, Mr. Harrington?
Resting close.
All right, then, Mr. Snodgrass, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense, the lesser included offense of that which is in the indictment. The court will follow the plea bargain, punishes you as a Class A misdemeanor under 1244 of our penal code, sentences you to 85 days in the Henderson County Jail. However, you already have credit for 85 days and orders you to pay your attorney's fees, court costs, and lab restitution fee. And Mr. Snodgrass, I need to go over just a couple more things with you. Have you had an opportunity to review the judgment of conviction in your case?
Excuse me?
The judgment, did you get a chance to look at it?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
And finally, sir, now that you've been convicted of this state jail felony, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. All right, sir, you need to see Mr. Halbert to your right. Sir.
If I could just talk to Mr. Carpenter, I'll be right back.
Sure. Here, Mr. Scott, he might be next door and see if he has. Yeah. We have Shamar Willis. I'm just going to go through the docket. If you hear your name, just let me know you're here. Okay. Oh, we got Miss Thompson with us. Anybody seen Mr. Stevens? Oh, Brad?
Oh, his case has been disposed of. That camps, I think it was.
Is that done?
I believe the officer submitted the dismissal.
All right, Miss Mayhall, Miss Thompson, you there?
Yes, Your Honor, I am.
Turn that TV down. All right, and where's, is it Beatty? How do I?
Biet, Your Honor.
Biet, Miss Biet?
Yes, sir. Your Honor, she called me.
She out there?
I'm here on video.
Oh, she's on, what's she doing on Zoom?
Your Honor, may I go ahead and speak?
Yeah, well, let me get her, because I can't see her.
I can't get it to come on video on my phone. All I can get is the voice to come up.
All right, Ms. Thompson, go ahead. And I'll note for the record, she's not in.
Your Honor, she notified me yesterday that she's been exposed to COVID and did not feel that she should come to court having been exposed to COVID. I did notify Kevin of this yesterday and contacted her and given her the Zoom information for today.
Can I see the docket sheet? You mean she was exposed to COVID? How do you know you're exposed to COVID unless you get a positive COVID test?
The people called me and told me
I'm
that they
asking
were.
Ms. Thompson, ma'am, I've not placed you under oath. I'm asking Ms. Thompson.
Your Honor, I would have no idea how she exposed. She just told me that she was exposed by some folks that she was trying to get a hold of to confirm it.
Well, I'll note that on the 7th of April, a little less than a month ago, she tested positive for methamphetamine. And I probably told her that she was going to test again today when she showed up. And so, I mean, if you want to call her, that's on you, Ms. Thompson. But all I know is that.
Call her
Okay, then.
for the limited purpose of this hearing today.
Sure. Ms. Biat, can you hear me?
Yes, sir.
I'm going to have you raise your right hand. Let me know when it's raised.
It's up.
All right, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Thompson.
Miss Biat, go ahead and state your full name for the record.
Martha Ann Biet.
Okay, Miss Biat, did you contact this office yesterday to inform that you'd been exposed to COVID?
Yes, ma'am, I sure did.
Okay. How is it that you believe you were exposed to COVID?
My daughter had called me and told me that they, the party that we went to, the birthday party that we went to, 2 of the kids had tested positive, and one of the parents had tested positive. I have tried to get a hold of them to verify that. I did go to the emergency room too.
Okay. Did they do a COVID test while you were there?
They told me as long as I'm not running fever, they can't do the test because they are limited on tests.
Okay. Did you try to go somewhere else to get COVID testing?
No, ma'am, I didn't, due to the fact that I don't have no money and I don't have no insurance to pay for it.
I don't think it costs money to get a COVID test.
Have you tried checking with the local grocery pharmacies? I think the Butcher's gives free COVID testing.
No, ma'am, I was not aware of that.
Pass the witness, Your Honor.
No questions for this witness.
Don't mind if I ask her some questions?
I'm okay with that.
Ms. Biat, how old are you?
I'm 51.
Why haven't you already received a COVID vaccination then if you're concerned about being exposed to COVID?
Because I have no insurance.
You don't need insurance for a COVID vaccine, ma'am. The federal government has provided it for no charge. Actually, the taxpayers have through the federal government. So I can understand if you don't want to get a vaccine, that's your choice. But if you're concerned with getting the COVID, I would assume then you don't want to get it and you just might as well get a vaccine then, shouldn't you?
I'm sorry, I didn't know they were free. I don't watch television, so I don't, I just see things over my phone. I don't watch television.
Well, if you don't watch television, how in the world do you know about this COVID stuff?
Just what I read over my phone.
Okay. Here's what I'm gonna do, ma'am. I'm gonna order you, when I have the other one coming in. I'm gonna order you to come into the courthouse tomorrow at 1:30 to take a drug test and to see me. I'll be in court.
Yes, sir.
If you're running a fever, they will tell you at the front and not let you in. But I'm gonna tell you, there are COVID vaccinations and tests available free of charge. As a matter of fact, I watched the news and I heard that they have more vaccines than people that are willing to take them. And if you live in Tarrant County, they're even thinking about giving people $50 just to take one.
I want one. I mean, I'm not refusing to take it. I just didn't know that, they were free.
Well, I'm not telling you have to. I'm just saying if you want to, they're out there. So
I would
anyway,
love
I
to.
will see you then. I am resetting your case for tomorrow at 1:30. You'll come in, you'll see me, and then I'll have you go take a drug test. If you're running a fever, they won't let you in the building.
Yes, sir.
And also, just so you know, if you go to any healthcare provider with COVID-related things, it doesn't cost you any money. The taxpayers are picking it up.
Okay.
All right, you're free to log off. We'll see you at 1:30 in person.
Okay. Thank you.
Thank you, ma'am.
Your Honor, that's all I have to this afternoon, sir.
Yes, ma'am. Thank you. Mr. Stevens.
Savannah Boykin, please. We called her earlier, we said it, but we went ahead and.
Oh, okay.
So you might have marked on.
Right, I'll find it. Thought I found it. Find it. There you go. There she is. Miss Boykin coming in? Oh, there she is right there. I thought she was coming in the door. All right, come on up, Miss Boykin. All righty, this is cause number CR 20-0644-392, the state of Texas versus Savannah Nancy Ellen Boykin. And this was set for pretrial today, and the court held pretrial. However, a plea has now been presented to the court. Is the state ready?
Yes, Your Honor, state's ready.
And on behalf of Ms. Boykin,
Defense is ready.
all right, Ms. Boykin. All right, let's see. All right, ma'am, is your name Savannah Nancy Ellen Boykin?
Yes, sir.
And can you pull that down? Do you mind? And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of driving while intoxicated?
Yes, sir.
I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Boykin, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out that you're not, and you enter into this guilty plea, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Boykin, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
Yes, sir.
And the court's going to find she is competent. Ms. Boykin, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the court?
No, sir.
But do you understand the
Yes,
charge?
sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that
Yes,
range
sir.
of punishment? And the plea bargain?
Thank you, Judge. The agreement is for 10 years in prison, but to be probated for 10 years. With $1,000 fine, attorney's fees, court cost, AA and or NA meetings as a condition of this probation, $50 to Crime Stoppers, urinalysis testing, obtain GED within 24 months, 400 community service hours, attend victim impact panel within 90 days. She's to take the repeat EWI offenders program, complete substance abuse evaluation and follow their treatment recommendations, to install an ignition interlock on any vehicle driven by her for half the probationary period. She's to do 10 days in jail as a condition of this probation with credit for 10 days served. That's all conditions.
Right, and I wrote in for half the period because there's a line to write that in. I wrote it in there. To install the interlock device.
Thank you, Judge.
Okay. And has she already done that? You given her credit for the 10 days?
Yes, Your Honor.
Okay. All right, Ms. Boykin, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Stevens, is that your understanding?
Yes, sir.
Well, Ms. Boykin, a few minutes ago, you told me you could read and write the English language. I'm going to go over two of these documents with you. The first is the agreed plea recommendation. Did you read and go over this with Mr. Stevens, both the front and the back?
Yes, did we? Are you asking if we did?
I'm asking.
Yes, sir.
And did you sign them?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages and sign this second?
Yes,
one? Well, let me totally finish the question first, okay? And do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, man, how do you plead to that third-degree felony offense of driving while intoxicated as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence states 1, 2, and 3. The offense report 2 is the blood toxicology results, and 3 is Martin compliance.
No objections.
Nothing further. Let's be closed.
Admitted. Anything from the defense?
No, Your Honor, rest and close, ask the court to follow the plea bargain agreement.
What, just for curiosity, what was the BAC?
It's the second page on states 2.
I see it.
I think it's something like that.
0.264. I've seen them higher, but that's pretty high. Ms. Boykin, I'm going to accept the plea, but I'm going to tell you, if it's one thing to have a drinking problem, but to have a drinking and driving problem, there's a lot of really stupid reasons to go to prison. And I tell people all the time, DWI is the dumbest reason in the world to go to prison because there are real criminals in there. People that have a lot of DWIs and go to prison, they just have a problem drinking and making bad decisions. And so I hope you're not headed that way. All right, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of driving while intoxicated as alleged in the indictment. The court will follow the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice. However, the court will probate that, place you on community supervision for 10 years. You do have credit for 32 days as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision. And Ms. Boykin, I'm sure with all these DWIs, or at least with the 2 that you've had, you've been on probation before, haven't you? Did you successfully complete them?
Yes, sir.
So you know what it takes?
Yes, sir.
Were those misdemeanor DWIs you were on? Probations?
Yes, sir.
All right, well, this is a felony. You know what can happen to you if you violate this probation? What can happen?
I go to prison
For how long?
10, probably 10 years.
10 years, you understand that?
Yes, sir.
Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be held in the county jail with no bond, you'd be brought back before the court, and at a hearing, if the court found that you violated even one term or condition, the court could revoke your probation and sentence you up to 10 years in prison. You understand that?
Yes, sir.
And again, I don't want to do that, but I could.
Yes, sir.
You understand that?
Yes, sir.
All right, good luck to you, man. You
Thank
see
you.
probation.
Thank you, Judge.
And if you got a drinking problem, which evidently you must, see somebody. There's lots of help out there.
Yes, sir.
Might be excused, Judge.
Yes, sir. Thank you.
See you this afternoon.
See you. 0.39 when I was working in a county attorney's office years ago with a 0.39.
Went for a break, talked to Mr. Strong on Mr. Gonzalez's.
Mr. Scott went back across the street, across the hall.
He was gonna meet with Scarlett.
Okay. Yeah, we'll take a break. It's, so we'll go ahead and take a recess and we'll just reconvene about 10:45 unless you get something sooner.
There you go. Got slammed, man. I see it.
Nah, I'm good. Few more years now, I ain't gonna, right. I don't know about that, but it's gonna be close. Probably really good time. What I'm gonna do right there. Yeah, I'm gonna do something else. I don't know, I might move it out or something.
All I did was ask him the same questions he was going to ask me. I said, hey, Carol, this is what, he's going to. Yeah, that's what I'm trying to tell him. He was doing I don't know what about, I don't know what I'm gonna do. The last year, so we're gonna figure it out. I'm gonna take some time off. And figure it out. Then I'm gonna get another job with this. Depends on where I'm living at. And all that you brought up. Somewhere I wanna be, maybe. On the outside, I ain't talking about like. I want like something like 4 I don't know what you're doing. Frisco is more expensive. I don't want to be too far out. That's all it's too far away. I want to be somewhere where I can, 20 road to my folks. Oh, I felt so weird like it. Max hour work and stay at work would be 4, I don't want too much insurance. Listen, you might stay with Ross and try to actually be like AFP. That might just be okay. That's the thing, like, I'm talking about not just for the company. Go around and have a issue to. My issue,
yeah, I'm ready when I'm ready.
I said, my son, yeah. 1 year left, my son, so they give him 2 working years. Well, yeah. But right now, I still out.
Okay. And how's the right ratio? They call me. Yes. That time. Okay. I'll say prosecutor anyway.
Hands on. Oh, can I get a copy? Yes. It's. I'm like, oh,
prosecutors back there.
Well, I told them 10:45, but they said you were ready.
I just got to try. You look so handsome.
Thought we were gonna put the microphone right there. It's all right. We can do it at lunch. I think it'll work a lot better.
We've got some of those stains, you know, like that used to be on the.
Oh, yeah, yeah.
You could just sit right there and. like, hold it up.
I recommend some content to watch to do a voice search.
Y'all, are they going hot and heavy over there?
Yeah. I was in line ready to go and they just started one of my hearings. So I had to run over there. They're still going. Thank you. She's in the
We ready? Are you ready? Mr. Willis, come on up, sir.
I think it was page 5, Your Honor.
I got it.
For
This
pretrial.
is cause number CR 20-0681-392, the state of Texas versus Shamar Willis. Set for pretrial, any pretrial from the state.
Yes, Your Honor.
No objection to that, Your Honor.
Granted, and on behalf of Mr. Willis,
Well, Your Honor, I'd advise I don't have any contested pretrial. I'd advise the state, I'd gotten DVDs from them and a couple of them I was having difficulty watching. So I think we're going to get that fixed, but assuming there's nothing on there, I won't have any pretrial matters.
just let me know if you do. All right, well then, Mr. Willis, court deems pretrial is held. Your next court date is June the 3rd at 1:30 for status. And typically that's your last day to resolve your case by plea bargain or otherwise remains up on the trial docket. Okay, sir? Yes, sir. Does he have an offer?
He does, Your Honor. It's, well, I haven't gotten it in writing, but Laura Carpenter told me she would probably be offering 5 deferred. I've made another counter offer to her and we're still discussing that.
All right. All right, we'll see June the 3rd, 1:30.
Yes, sir.
Thank you. I also have a Sheila Crady. She's not here. She's probably still in the county jail, but it's a incompetency, agreed incompetency situation. And you signed off on an order of commitment.
I don't have anything.
We submitted the 60 day. I think it was signed.
Yeah, you signed off on an order committing her, so she's supposed to go off to Terrell, wherever it is it's gonna be.
60-day restoration of competency.
I guess, yes. I don't, is it only 60 days?
I think it was 60 with the possibility.
120, up to
Is it the one, up to
120,
120?
yeah. Yeah.
Starting out.
Yeah, Kevin took them off.
Okay, good deal. Thanks, Your Honor. That's all I have until this afternoon. Maybe excuse. See you.
I was going to take a break and he texted me, said John was ready. So I come back in. Are we ready on anything else?
Judge, we're getting some plea papers on Mr. Gonzalez. We'll have him resolved today.
Okay.
We're working on that.
All right. So you haven't even gone over them with him?
No.
Okay. And
We
then
know what the deal is and
I understand. Mr. Harrington, are you ready on anything?
No, Your Honor, we thought we may have a plea this morning, but I didn't speak with this part.
Okay, I'm gonna take a break. Y'all just let me know when you got something ready.
Those are the last two we have.
Yeah. So
Thank you, Judge.
Thanks, Judge, for coming out. Taking care of that. No problem.
Just an idea of using the wireless mic. Right here, when you, if it should go over here, and you should be here first.
It's mounted on the board.
June 3rd, 1:30.
That was moved.
Yeah, June. Yeah, it's June 3rd at 1:30. Thank you.
Well, they're not in, but I reprinted them. There was some already in the files. I just printed it off. To verify that.
Good to see you. Yes, sir. Changes some kind of file. So let me, I think you will. Let me check. Yeah, okay, I will. Thank you.
She was printing off. Yeah, it was.
No.
I was getting those things out. That's it. I was doing this. And there, I was. I figured.
Did you have to file?
No, it's a. I think it's. Yeah. Right.
I know, I thought we were.
Oh, just. I like that. Yeah, okay.
Something else on the way.
And you can still allow less than those over there. Yes. Yeah.
I didn't know that was happening.
Yeah.
No, actually,
I think that he ran. Yeah, that's time. And the time before he ran. Yes, as a Democrat. And they tried to, they tried to do this time. Apparently, more people make it. Yeah, Obama. He had a picture. Yeah. Very good.
I'll order post office because honestly, they're all.
Yeah, I think he meant, yeah. The way this, I like how they wrote the article that he's choosing to retire. Because he's too old. Yeah, they made it sound like he had made the decision. Remarkably, he always did well. Yeah. Times that I went in there. But there's yes. Oh, the worst. She chewed me out for sitting and yelled at your mom on my class testified at the trial. I wore slacks and a button down. And it was, cause you feel that's how I got. Yeah. You're a attorney. I expect you were both sides. Oh, did you? Yeah. He was Terry Russell. Terry Russell. Yeah. I don't think it was. I don't think so. I think it was whatever that is. The silence or whichever one Terry Russell had. Sitting there very long. That when he was, over Court of Appeals? No. Okay. Oh.
I guess he's on.
I moved to Baltimore. To check college football again in Baltimore. Sure as I did, I was arrested. So I just walked out by. Yeah. I've been doing just straight college since 14. Before I did hospital college. Work Friday and Saturday. Hadn't been much fun the last, since COVID. Yeah, it's just a restraint. Yeah, this is just, this is Certainly. neighbor. Yeah. I was surprised. So many,
Those are the scary ones.
there were so many of those years that I thought, well, that's so bad. This one, that was kind of what they ended up. Oh, it was awesome. Or large. You know, that's like. Are you lying good? You know? Yeah.
I had to shake it. I got the paint job. I need it. Was definitely not. It goes a lot slower.
Worthing's a nice guy, but hey, yeah. They said 80 years old had improved.
I think they report. Yeah, I mean. Oh, okay. Then never mind. Oh, okay, you were.
Dan, remember what day that hearing was on Stevie?
I believe it was a Wednesday afternoon last week, so 28.
Marissa.
Yeah, yeah. Hooper. No, I think she's doing that.
Oh.
So this one is-
Yes.
It's an anticipatory title.
I don't know.
I know that was.
June is the new sign.
All right. Be seated. Thank you. Maybe we'll see if it works.
No, I can't wait to see what it's gonna change my sound.
All righty. Let's see, who do we have? Mr. Gonzalez, come on up, sir. All right, this is cause number CR 20-0616-392. State of Texas versus David Gonzalez Jr. And that was actually set today for pretrial. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor, state's ready.
And on behalf of Mr. Gonzalez.
Mr. Gonzalez is ready, Your Honor.
All right, sir, is your name David Gonzalez Jr.?
Yes.
And if you can pull that mask down for me, please. It's just a little easier for the court reporter and I to hear you. All right, and Mr. Gonzalez, are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of burglary of a building in count 1 of that indictment?
Yes.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Mr. Gonzalez, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Gonzalez, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes.
And Mr. Green, do you believe your client is competent?
I do, Your Honor.
And the court's going to find he is competent. Mr. Gonzalez, I know you were already arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No.
But do you understand the charge?
Yes.
Well, as indicted in count 1 of that charge, that burglary of a building is a state jail felony. A state jail felony carries a punishment range of not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine up to $10,000. Do you understand that range of punishment? And the plea bargain.
Thank you, Judge. The agreement on count 1 is for 15 months state jail, plus attorney's fees, court costs, restitution, $3,000 to State Farm Insurance, $500 to the victim in the indictment. Mr. Anthony Whitted, state will ask the court to take into consideration count 2 and also an unfiled manufactured delivery of a controlled substance.
Is that your understanding of the plea bargain, Mr. Gonzalez?
Yeah.
Is that your understanding, Mr. Green?
It is, Your Honor.
Well, Mr. Gonzalez, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 of the documents with you in this packet. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Green?
Yes.
And did you sign the front and the back?
Yes.
Do you have any questions about it?
No.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes.
Did you sign the second page?
Yes.
Do you have any questions about it?
No.
Do you have any questions about any of the documents that you read and went over with Mr. Green?
No.
Or if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to enter into this plea bargain?
No.
You don't?
Oh, yes. I'm just.
Do you want a trial or the plea bargain?
No.
Do you want the trial or the plea bargain?
Yes. And I'm supposed to say yes or no? You
I don't know.
Say you want the plea bargain. Oh, plea bargain.
Okay, it's just got to be clear on the
This is
record.
new to me.
It's okay. All right, this glass is difficult. I understand it. Well, then I'll ask you, sir, how do you plead to that state jail felony offense in count 1 of the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? I'll hear the evidence.
Thank you, Judge. State offers into evidence states 1 and states 2. States 1 is the offense report and states 2 is work compliance.
No objection, Your Honor.
Submitted.
Nothing further. Rest in close.
Rest in close, Your Honor.
All right, then, Mr. Gonzalez, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of count 1, that burglary of a building. The court will follow the plea bargain and sentencing you considers the indicted and unindicted cases annotated on the plea sheet. Follows the plea bargain again, sentences you to 15 months in a state jail felony facility. You do have credit for 232 days. and orders you to pay your attorney's fees, court costs, and to pay the restitution to State Farm Insurance. And before you go, just a couple more things to go over with you, Mr. Gonzalez. Have you had an opportunity to review the judgment in your case? Is your name, the charge, and the time credit correct? And finally, sir, now that you've been convicted of this felony offense, you're now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. You're now remanded back to the custody of the sheriff. Serve out the remainder of your sentence. Good luck to you, sir. You need to see Mr. Halbert to your right.
Judge, that's all my business. May I be excused?
Yes, sir. Appreciate you. All right. You ready, Mr. Green?
Yes, sir.
Mr. Hooper, come on up.
This pre-trial, we have a plea offer, plea agreement.
Okay. All right, this is cause number CR 20-0530-392, the state of Texas versus Ricky Hooper. This was set for pretrial today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Hooper,
We're ready, Your Honor.
all right, sir, is your name Ricky Hooper?
Yes, sir.
Can you pull that mask down for me a little bit? That way I can hear you. Thank you, sir. All right, and Mr. Hooper, are you the same person that was originally indicted by Henderson County Grand Jury for the second-degree felony offense of aggravated assault with a deadly weapon?
Yes, sir.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand.
I need one break and talk to Mr.
Okay.
Harrington for a second.
That's all right. Yeah, I think y'all need to figure this out because I don't know how you're gonna do this. Right? How do you abandon the deadly weapon on a second-degree ag assault?
You can do that for parole purposes, Your Honor.
You can?
Yes, Your Honor.
Maybe it's just been a while since I've done something like that.
My excuse.
I'm thinking. I guess you can abandon the deadly weapon on an ag assault even though it's included in the indictment?
That is correct, Your Honor.
That's my understanding. I know they did some research on it. So it makes it, what, I guess not a non-3, it's not a non-3G.
It just makes it a non-3G, but it's still a second,
That is
and it's
correct.
still
Your
an
Honor.
aggravated assault with a deadly weapon, but the state can abandon it?
Yes, Your Honor.
Guess so. I guess I just never done that before. Maybe it's been so long, or maybe it's because it feels like a Monday. I don't know.
And Your Honor, the only thing is, there was an enhancement paragraph.
Right,
and-
y'all
and
are
the one-
abandoning that.
Yes,
It's not on this plea sheet, but I'll,
that is correct, Your Honor.
okay. Well, it doesn't say he's pleading any enhancement, so
That's true. Yes, Your Honor.
I'll just, so has the state filed a motion to abandon it?
That's what we're doing right now.
Okay.
Yes, sir.
That's what I'm saying. But an ag assault is a 3G. But I just put them this way. Got where I was. I think I swore him. Okay, that's what I thought. All right, Mr. Hooper, I just previously swore you in. And you're the same person that was indicted for this offense. Is that correct?
Yes, sir.
All right. All right, Mr. Hooper, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
I understand.
And Mr. Hooper, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here?
Yes.
And Mr. Harrington, do you believe your client is competent?
Yes, sir, I do.
The court finds he is competent. Mr. Hooper, I know that you were already arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand the range of punishment?
I understand.
In the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty of aggravated assault with a deadly weapon, this agreed plea recommendation is 8 years Texas Department of Criminal Justice Institutional Division with time credit of 230 days as of today, $750 in attorney's fees and court costs. The state's abandoning the finding of a deadly weapon and abandoning the enhancement paragraph.
I'm looking at your judgment real quick. I'm sorry. Yeah, give me just a minute. Okay, I see it. So this is the edited one. All right, I'm gonna get that back to you. Is that your understanding of the plea bargain, Mr. Hooper?
Yes, sir.
Is that your understanding, Mr. Harrington?
It is right.
Well then, Mr. Hooper, a few minutes ago, you told me you could read and write the English language. I'm gonna go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Harrington?
Yes, sir.
And did you sign them?
Yes.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Harrington?
No, sir.
Well, if you read and went over these with Mr. Harrington, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that second-degree felony offense as alleged in the indictment? Are you guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
No.
Now, is there any other reason other than you are guilty?
All right, good, sir.
Okay, I'll hear the evidence.
So, Your Honor, state offers State's Exhibit 1, the offense report, State's Exhibit 2, the discovery inventory report.
Admitted. And has the victim been notified and on board with the plea bargain?
Yes, Your Honor.
Okay.
State rests and closes.
Rest is closed.
All right, then, Mr. Hooper, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense as alleged in the indictment. The court will follow the plea bargain, sentences you to 8 years in the Texas Department of Criminal Justice. You do have credit for 230 days and orders you to pay your attorney's fees and court costs. And Mr. Hooper, did you have an opportunity to review the judgment in your case?
Yes.
It doesn't have a second page. All right, was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And finally, now that you've been found guilty of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. So if you have any questions about that, just consult with an attorney.
Yes, sir.
And sir, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Hooper. You need to see Mr. Halbert. Well, you're not ready yet, are you? Just have a seat, Mr. Hooper, and when that judgment comes in, he'll have to thumbprint you, Judge.
Maybe excuse Judge.
Yes, sir. Appreciate you. Uh-huh. When Mr. Harrington was speaking, I could hear him a lot better. Now, maybe the game, that gaming mic, what'd you do with that? That might even pick it up even better. Because that's a omnidirectional, right? Well, that one is too, I guess, but
That was the one they couldn't hear on Zoom. They couldn't hear you. They could hear you. And that's why we got the.
Yes. Yes.
This was on Mr. Willis.
It's on the Willis case right here. Yes. It is an information. It is an information. I just want to make sure that it is not a form. Yeah.
Yeah.
Sir? Yes, sir.
Let me pass by you earlier.
Yes, sir.
Excuse. So it looks like you were wrong. Huh?
You're gonna get on her for that?
Oh, no, I didn't sell for a hearing. I sold for a truck.
You told me earlier that you were, and I almost responded, but I'm going to now. You said, I told Kyle Steele I wasn't trying to be an asshole, and I was gonna say, you don't have to try, you are.
Steve,
All right, ladies and gentlemen, here in a few minutes, we're going to take open announcements on the 1:30 docket. For those of you appearing via Zoom, please keep your microphone muted until it is time for you to testify or your case is called. Also, if you don't click that stop video button, we can all see what you're doing. And although it might be funny and entertaining, if you wouldn't do it in a courtroom, please don't do it on Zoom. Just stop your video if it's not your time for your case. For those of you in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. It's not my decision. It's your personal decision. The inmates are in masks because they're required to be here. Other than that, it's up to you. And so with that, Ms. Fallhaber.
Thank you, Your Honor. I've got Christy Ringel on page 1.
All right. Looks like she's got an arraignment too. All right, these are cause number CR 21-0063 and CR 21-0243-392, both styled the state of Texas versus Christy Riggle. And let's handle the arraignment on the 243 case first.
Yes, Ms. Riggle, her name is spelled correctly. She waives reading of the indictment, enters her plea of not guilty.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. And let's go ahead and go to the 0063 case on discovery status. Where are we at on that?
Your Honor, I believe all discovery has been provided in this case. There are offers in these two cause numbers.
I'm sorry?
There are offers.
What are the offers?
The offers are probation.
That would be wonderful,
I'm
but that's
sorry.
not.
No, I'm looking at the wrong case. It's 10 years TDC concurrent with 5 years TDC.
Okay. All right. And so then what I'm going to do is, Ms. Riggle, I'm going to pause your the earlier case and let this new case catch up with it. So your next two court dates will be July the 7th at 1:30 for discovery status on both cases. I'll just reset the other discovery status. And then on August the 4th at 1:30 for pretrial on both cases. And so if you get out of jail between now and July, I need to see you back here on July 7th at 1:30. All righty. All right, as soon as you receive your reset notice, you can have a seat.
Thank you, Your Honor.
Yeah.
We're gonna just read the back. You got the- so, okay. Thank you.
Mr. Shackelford, how are you? Haven't seen you in a while.
I know, it's been a minute.
What's that?
So it's been a minute.
Yeah. Right up here, sir. All right, this is cause number CR 20-0386-392, the state of Texas versus James Mullen, and this is set for discovery status.
Discovery has been provided to the defense, Your Honor. There is an agreed or an offer. It's for probation. It's 10 years TDC probation.
Okay. And you have any issues with discovery, Mr. Shackelford? Think you got everything?
I think we've gotten everything, Your Honor.
Okay. All right, then, Mr. Mullen, the court then deems discovery status is held. Your next court date is on June the 2nd at 1:30, and that is for pretrial. And so just make sure you stay in touch with your lawyer and your bondsman, and we'll see you on June 2nd at 1:30.
Judge, would there be an available date after that, maybe?
July 7th?
July 7th?
And some of these dates may move anyway. I don't even know what my summer looks like yet. And I won't for about another month or so.
Can we take?
July or sooner?
No, can we do July 7th? Does that work?
July 7th?
Is that?
I just saw that date because that's some other dates. July 7th, 9 a.m.
Thank
That
you,
works?
Judge.
All right, so we'll see you on July 7th, 9 a.m.
May we be excused?
Yes, sir. Good to see
Thank
you.
Good to see you as well.
Mr. Scott.
Not here. She had gone to ER yesterday and she's been in contact with me. And she notified me that she had a fever and was around an elderly lady that had been confirmed positive for COVID.
Who is it?
Jessica Flatt, Flatt. She's set for, I believe, arraignment and a bond reduction hearing.
I don't have a Jessica Flatt. Maybe it's on one. With Jessica S.
No, I've got Jessica Estes too. I thought she was on the docket today. Y'all have her case tomorrow. Okay.
Looky there,
well-
you're early.
Well, maybe I could just go ahead and show this to the court and save some time. She's went to the doctor and they did a COVID test and they've asked for her to be quarantined or excused from work for 7 days.
Okay, that's fine. Let's just reset her. That way it won't even be on tomorrow's docket. You don't, I believe you if you say.
Okay, thank you, Judge.
Okay.
You want to try to do it next week?
No, she's gonna be quarantined for 2 weeks.
The thing says 7 days, but 2 weeks is fine, whatever.
It's fine.
Thank you, Judge. I got
Yes, sir.
2 others on the side.
Sure. Ms. Altier,
Yes, Your Honor, on the top of your Alexander Hyatt's status.
is it height or hit?
I say height. We'll find out.
I say height too.
Yeah, he is here.
Okay. May I see the docket sheet? Okay. Come on up, Mr. Height. This is cause number CR, is it height?
Hi.
Hi,
Hi.
T is silent.
HIG, what?
What? What did you say?
Hi, HIGC?
Yeah, that's what I said. Is that how you pronounce it?
Yeah, yeah.
Okay. It's hard to hear you when you just say yeah and huh,
yes.
rather than yes, your honor, or no, sir, yes, sir. I call you sir. It's just general, everyday politeness to people.
Okay.
It's kind of the way I look at it. Is that understood, sir?
Yes, sir.
Gotcha. All right, this is cause number CR 21-0010-392, the state of Texas versus Alexander Height, and that is set for discovery status.
Discovery's been provided, Your Honor. There are 2 offers in this case. One is on felony 3 for probation. The other offer is for jail time under the lesser included.
Okay,
We do have all the discovery and we do have the offers also, Your Honor.
all right. All right, well then, Mr. Height, the court will deem discovery status as held. And so I'm going to reset your case, sir, to June the 2nd at 1:30. However, before you go, based upon the nature of your charges and the fact that you have already failed 1 drug test, I'm ordering you to take a drug test today. You'll go take the test. When you get done, come back in the courtroom. We'll go over the results together. Do not leave until we talk.
Okay.
May I step down until the drug test is done?
I'm sorry.
May I step down until the drug test
Yes,
is done?
yes, ma'am. Thank you. Sure. All right.
Jessica Estes.
And I do have her on the bottom.
All right. At least I got
Jessica
one.
Estes.
PTI application. So we don't sign the waiver of jury unless. it's
Unless she's
accepted,
accepted.
right?
Yeah, 'cause you don't-
Yeah,
No.
right.
But if she's accepted, then we don't go through that whole program.
Okay.
Try to change it.
All right, this is cause number CR 21-0013-392, the state of Texas versus Jessica Estes. And that is set today for discovery status.
Yes, Your Honor. The state has made an offer for offer for a PTI pending approval of her application. And she submitted that today and she's paid her PTI fee. So we have this case resolved as long as that's approved. I've been given discovery in this case. I don't have any reason to believe that I don't have anything, but that's where we are on the case, Your Honor.
Your Honor, if we can just reset it pending that approval, if she gets accepted, we'd ask for a waiver of jury trial. And if she's not, then we can just go back to it.
Well, I mean, I needed to send her for a drug test. She hadn't drug tested yet. And so, okay, well then the court deems discovery status is held. Mr. Estes, I'm going to reset your case for pretrial to June the 2nd at 11:30 if needed. But before you go, I'm going to order you to take a drug test. You're going to go with probation, take the test. When you get done, don't leave, come back in the courtroom and we'll go over results together. Thank you, ma'am.
Okay.
At Willingham?
Well, I don't think, last time I checked, he wasn't here yet. Let me go see if he's outside.
Okay, I won't call it.
And that's a police, so I'll have to fill in the papers.
Ms. Moore,
The topic case before Danielle Oliver.
I don't think that guy understood what I was saying. Or maybe he couldn't hear me. All right, this is cause number CR 21-0059-392, the state of Texas versus Danielle Cullifer. Is there a Miss Cullifer in the courtroom? I see no one. I hear no answer. There's not a Miss Cullifer on Zoom. The time is now 1:42. The docket was set for 1:30. The court will entertain a motion.
Thank you, Judge. State request bond forfeiture at this time.
Granted, capious issue shall be held with no bond. And if you find her,
I'll wait around a little bit. I'm surprised she's not here.
let's see, I see Ms. Thompson. She was thinking first. Ms. Thompson, you with us?
Yes, Your Honor, I'm with you.
Okay, you got something ready?
If he's there, it's Christopher Thompson for arraignment, Your Honor, and he was en route.
Christopher Thompson. I've got it set for discovery status.
You are correct, Your Honor. It is discovery status.
Up here, Mr. Thompson, and you can see your lawyer right there. She's appearing via Zoom. All right, this is cause number CR 20-0641-392, the state of Texas versus Christopher Thompson, set for discovery status.
Your Honor, discovery's been provided in this case. There's currently two offers. One is for probation and the other is for jail time.
Okay. Did you hear that, Ms. Thompson?
Yes, sir.
I did,
Mr.
Your Honor, and that
Thompson,
is correct.
All right, and you heard that too, sir. You both had the same last name. That's what confused me. All right, well then the court deems discovery status is held. And Mr. Thompson, your next court date is June the 2nd at 1:30 for pretrial. And may I see the docket sheet? All right, and based upon the nature of your case, Mr. Thompson, I'm ordering you to take a drug test today. You're going to go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together. So just don't leave until we talk.
All right.
Yes, sir. Got anything else, Ms. Thompson?
No, Your Honor, I believe that's all I have this afternoon.
All right, thank you.
Thank
Are you
you.
going to hang around and wait for the drug test?
I am going to wait for a little bit, Your Honor. Sure. am.
Okay, thank you. Mr. Green, you got something? Ready?
Judge, I have 3 discovery status hearings.
Okay. Just want to go in order?
Yes, sir, that's fine.
Mr. Gilmore, come on up, sir. All right, this is cause number CR 21-0060-392, the state of Texas versus Ronnie Gilmore. And that, your attorney's right there. That is set for discovery status.
Discovery has been provided, Your Honor, and there is a offer in this case. It's for TDC time,
How much?
12 years.
Okay, 12-year offer. All right. All right, Mr. Green, any discovery issues that you're aware of?
Judge, I received discovery on the portal last week, which also included the plea offer. I have not had an opportunity to review it yet, but it appears, based on the nature of the case, that I have everything related to this case.
Okay. All right, then,
And I
Mr.
will-
Gilmore, go ahead.
And I will discuss that plea offer with Mr. Gilmore between now and the pretrial hearing.
Okay. All right, then, Mr. Gilmore, the court deems discovery status is held. Your next court date is June the 2nd at 1:30 for pretrial. And so we'll see you June 2nd at 1:30. Okay. If you get out of jail between now and then, I need to see you back on that day. Even if you break out of jail, make sure you're back here. Jeffrey Howard?
Yes, sir.
Jeffrey Howard. Mr. Howard, come on up. And your attorney's appearing via Zoom, so he's right there. He
Yes.
can see you. All right, this is cause number CR 21-0040-392, the state of Texas versus Jeffrey Howard, set for discovery status.
Judge, discovery has been provided in this case. There are currently two offers. One is for probation and the other is for county jail.
Okay. All right, and Mr. Green, any discovery issues that you're aware of?
None that I'm aware of, Judge. I'd had the same announcement I had from Mr. Gilmore. I got Mr. Howard's discovery about the same time last week. Have not had a chance to look at it yet. Also, I believe I picked up this morning when I was there a copy of a video. But as of now, there's no issues. I believe that we would have everything.
All right, then, Mr. Howard, the court deems discovery status is held. Your next court date is June the 2nd at 1:30, and that's for pretrial.
Yes, sir.
And so we'll see you on that date. You're going to get a reset notice, but based upon the nature of your charges, I'm ordering you to take a drug test today.
Yes.
You'll go take the test. When you get back, come in the courtroom. We'll go over the results together.
Okay.
Thank you, sir. Alvis Waters. I see the docket sheet on this one. All right. Mr. Waters, your attorney's appearing via Zoom. He can see you.
Yes, sir.
And he can hear you. All right, this is cause number CR 21-0025-392, the state of Texas versus Alvis Waters, set for discovery status.
Your Honor, discovery has been provided in this case. There's a current offer of 12 years TDC.
And Mr. Green, any issues?
Judge, same announcement as the last case, last two cases. Got Mr. Waters' discovery last week. Believe that I have everything, but have not had a chance to review it all.
All right, then, Mr. Waters, the court deems discovery status is held. And Mr. Green, if you find issues, I can always give you another pretrial if we need to.
Yes, sir.
The court's going to set your pretrial, Mr. Waters, though, for June the 2nd at 1:30. And again, that's for pretrial. So you're going to receive a reset notice for that date. However, based upon the nature of your charge, I'm ordering you to take a drug test today.
Okay.
You'll go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together.
Okay.
But don't leave till we talk.
Okay.
Thank you, sir.
Judge, that's all my business. I'll be available if you need me. Just ask Mr. Hensley to text me and I'll log back on.
Yes, sir. Thank you.
Thank you, Judge.
Mr. Head.
I have Kathy, I believe it's on page 2 on a discovery status.
docket sheet. Walter Kathy.
Your Honor, I was just gonna let the court know that we've contacted the JP court. Judge Duncan was on the bench, but his court coordinator said they would be fine working out a payment arrangement with Mr. Caffey. If he can report to the court, they'd rather have the fees paid than have him lay it out. But I told him,
I mean, they've got a capias out there. And so they need to withdraw it. If that's what they want to do.
and I think Judge Duncan is gonna call me back as soon as he gets off the bench. And I know Mr. Caffey, I guess will probably need to take a UA. I think today, I'm not sure about that.
Well, here's what, let me call a case then. This is CR 21-0025-392, the state of Texas versus Alvis Waters, and this is set today for discovery status.
Discovery's been provided, Your Honor. There are currently 2 offers. One is for probation, and one is for county jail time.
Your Honor, I apologize.
Oh, I read the wrong case. I'm sorry. Cause number CR 21-0042-392, state of Texas versus Walter Caffey. Sorry, I read the one above. Same announcement.
Yes, Your Honor.
Yes, sir, Your Honor. We've received the discovery.
Any discovery issues you're aware of?
No, sir, Your Honor.
All right, Mr. Caffey, the court's going to deem discovery status is held. Your next court date is June the 2nd at 1:30 for pretrial. I am going to order you to take a drug test. There is a capias out there for you. And so what you're going to do is you're going to go take that drug test. When you get done, come back in the courtroom. We'll go over the results together. And then we'll wait here. I'm going to have you wait in the jury box and see what Judge Duncan does.
I'll step out and take. I'll advise him, Your Honor, and I'll wait around, obviously. That's all I have.
Mr. Mills.
Hey, regard McKee.
David McKee. All right, this is cause number CR 21-0062-392, the state of Texas versus David McKee, and this is set today for discovery status.
Discovery's been provided, Your Honor. There's a current offer of 15-month state jail.
That's correct, Judge.
All right, then, any issues that you know of?
Not that I know of.
All right, Mr. McKee, then the court deems discovery status is held. Your next court date is June the 2nd at 1:30 for pretrial. And so we'll see you back on June 2nd, and once you receive your reset notice, you're free to go.
Just wait just a minute. I'll give you a reset. Rico Brown, page 3.
Rico Brown. This is cause number CR 21-0056-392, the state of Texas versus Rico Brown, and set for discovery status.
Judge, we've received the discovery in the case. And actually, as I was looking through the discovery in the case, I realized more I read that apparently this involved an alleged incident of family violence against a lady who my wife dealt with on CPS cases. I don't know if she was the actual ad litem for these kids that were present here, but there was another child that was involved. And so my wife has spoken numerous times with the complaining witness in this case. And so I hadn't even told Rico this, but I'm going to ask the court to replace me. There's obvious conflict there so that he can get another lawyer.
You understand that, Mr. Brown?
Yes, sir.
He's got a conflict. So, all right, who's next on the list? Where's our indigent defense coordinator? Or they got an arraignment doctor or something?
That's right.
Oh, she's being the court coordinator. Where's his coordinator? Okay, cool. Here's what I'm gonna do. I'm gonna reset discovery status to June 2nd at 1:30. And you don't know, is there any way that she can text you or let you know? I'd like to let him know before he leaves. So, yeah, Mr. Brown, if you'll go ahead and have a seat in the jury box, I'm gonna, I want you to know who your next lawyer is before you leave.
Yes, sir.
All right, thank you.
And you didn't give enough sample for us to send out. We wouldn't give more samples if we sent out.
Okay. Yes, sir.
Oh, I'm sorry, Jordan Wright. Bottom of page 3.
Jordan Wright. All right, this is cause number CR 19-0338-392, the state of Texas versus Jordan Wright. Is there a Jordan Wright in the courtroom? I see no one. I hear no answer. Is there a Jordan Wright appearing via Zoom? I see no one. I hear no answer. Time is now 1:57. This docket was for 1:30. Mr. Wright is not present. Court will entertain a motion.
Thank you, Judge. State request bond forfeiture in this cause.
Granted, capious issued, he'll be held with no bond. And again, I'm here most of the day.
Yeah, I don't know what the deal. I just talked to him yesterday, so. Maybe an issue. Robert Bradley, and that's a plea.
Bradley, come on up. Is he going to plea on the information? Is that-
Yes, sir. On that second number.
Yes. Well, you added one and then disposed of one, but still. All right. Do you have the paperwork? I don't have it.
No, you don't have. Sorry, Judge.
I thought it was your ink.
It's the ink. No, it shouldn't say broken. It's
Oh.
just not functional.
Inoperable.
I guess it functions, but you're not gonna be able to.
So where's the,
I don't know. We've
Well,
got all the
it'll take-
papers except the judgment, I think.
She's working on it. So.
okay. She's working on it now. Who's got the Smith County? Okay.
You want to come back in a second?
Yeah, let me handle this because Smith County's coming in. That way they're getting the judgment. You ought to step back and I'll call y'all next. All right, Mr. Murphy, you ready for Mr. Gillum?
Yes, sir.
All right. Do I have paperwork on these? Gilliam? Thought it was set for, is this set for a plea?
It is a plea, Judge. Yes, sir. And we, I know that we emailed paperwork this morning.
Y'all have the paperwork on Gillum?
Marissa, you have paperwork on Gillian?
Okay, they're not all signed.
That's all right. Hey, we're moving fast. It's a moving train. It's just your signatures it needs, Mr. Strong.
There's some also from the. They signed most of it.
I can get it. I can make it work. Mr. Gillum, just give us a second. We're getting your paperwork together, okay?
Yes, sir.
So if that's that case, it's that, well, yeah, let me hold on to that. If I can remember. But I think he's gonna give you different paperwork that he's signing. So I'll give you this one back. Right? Oh, he's doing two, is there two pleas here?
There are, Your Honor.
Okay, I'll just get started and then I'll hand everything to you. All right, these are cause number CR 20-0489-392 and CR 21-0051-392. And both of these are styled the state of Texas versus Colby Gillum. And for the record, the attorney for Mr. Gillum, Mr. Murphy, is appearing via Zoom, as is Mr. Gillum, who's appearing via Zoom from, I believe, the Smith County Jail. Is that correct?
That's correct, Judge.
Okay. All right. And so this is set for plea today and a plea on information. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Gillum,
We're ready, Your Honor.
all right, sir, is your name Colby Lee Gillum?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury in this 489 case for the state jail felony offense
Yes, sir.
of possession of controlled substance? Okay. And are you also the same person that's been charged by information in this 0051 case with the state jail felony offense of possession of a controlled substance?
Yes, sir.
What? It's a
I
plea.
thought they were both indictments.
Oh, these are both indictments? I'm so confused. I'm thinking of the previous one.
The
That's
previous
what I
one was
get.
an information. These are.
Let me back up, Mr. Gillum. It's not a plea on information. Are you the same person who was originally indicted by a Henderson County grand jury in that 0051 case for possession of a controlled substance?
Yes, sir.
It had that 21. So. All right, sir, if you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
You can lower your hand. Mr. Gillum, can you read and write the English language?
Yes, sir.
Then if you will direct your attention to the clerk here in the courtroom, she's got some questions to ask you about some paperwork you went over with Mr. Murphy.
Yes, sir.
I'll get track.
Colby Lee Gillum, is that your correct name?
Yes, ma'am.
Did you read and understand all the documents you went over with your attorney?
Yes, ma'am.
I'm going to show you the agreed plea recommendation for CR 20-0489. Can you verify for me? Is this your signature?
Yes, ma'am.
As
Yes,
well as
ma'am.
the fact?
Yes, ma'am.
I'm going to show you the judgment. Is this your signature?
Yes, ma'am.
I'm going to show you the agreed plea recommendation in CR 21-0051. Can you verify for me? Is this your signature here?
Yes, ma'am.
As well as on the back?
Yes, ma'am.
I'm going to show you the judgment. Is this your signature here?
Yes, ma'am.
And did anyone force you to sign any of these documents?
No, ma'am.
Thank you.
And Mr. Gillum, are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Gillum, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Murphy, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Gillum, I know that we've already arraigned you on each of these cases. However, would you like the prosecutor to read the indictments against you out loud here in our virtual and regular court?
No, sir.
But do you understand the charges?
Yes, sir.
Well, as indicted, each of those charges is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
In each case,
Yes, sir.
and the plea bargains?
Thank you, Judge. In CR 20-0489-392, the agreement is for 12 months state jail time plus court costs, 180 restitution to DPS. That's to run concurrent with CR 21-0051-392. Also at 12 months plus court cost and 180 restitution, and that cost, the state will ask the court to take into consideration an unfiled bail jumping from 11/12/2021
Is that your understandings of the plea bargains, Mr. Gilliam?
Yes, sir.
Is that your understanding, Mr. Murphy?
It is, Your Honor.
And Mr. Gilliam, a few minutes ago, you told me that you could read and write the English language. I'm going to show you a couple documents here. First is the agreed plea recommendation. Now, there's one in each case. The forms are the same, but the information's different. That's the one that had your plea bargain and everything on it. You
Yes,
see
sir.
that? Did you
Yes,
read
sir.
and go, did you read and go over that with your attorney?
Yes, sir.
Both pages of that?
Yes, sir.
All right, now, in this case, you have not signed that, but did you go over it with your attorney?
Yes, sir.
And Mr. Murphy, you didn't sign it either, but did you go over these with him?
We did, Judge.
And do you have any, now there's one for each case. Did you go over the one for each case?
Yes, sir.
Yes, sir.
And Mr. Gillum, did you understand it?
Yes, sir.
Do you have any questions about it?
No, sir.
All right, the next document I'm going to show you, and again, there's one for each case. It's just the cause number that's on the top that's different. This is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those or both of the pages of this document in each case?
Yes, sir.
And is that your signature there on that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Murphy?
No, sir. But at the same time, I do have 2 misdemeanors from out of the county. I don't know what. I'm just asking.
Judge, we're gonna take care of those once we take care of this.
That answer your question, Mr. Gillum?
Yes, sir. Thank you.
Okay, you're welcome. All right, well then, Mr. Gillum, if you read and went over these with Mr. Murphy, I know he explained to you that in each of these cases, you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in any of these cases?
No, sir.
Do you want to enter into this plea bargain
Yes, sir.
or these plea bargains?
Yes, sir.
And I'll ask you, sir, in cause number CR 20-0489-392, to that state jail felony offense as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And in cause number CR 21-0051-392, to that state jail felony offense of possession of a controlled substance, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence in each case.
Thank you, Judge. In each cause, there are 3 exhibits. States 1 is the offense report, states 2 is Morton compliance, and states 3 is the lab report.
No objection.
In both causes.
Right, and admitted in each cause.
Nothing further, rest and close by the state.
All right. And Mr. Murphy, anything on either case?
No, Your Honor, we'd rest and close as well.
All right, then, Mr. Gillum. In cause number CR 20-0489-392, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court, in punishing you, considers the unindicted bail jumping case as annotated on the paperwork. Court sentences you to 12 months in a state jail felony facility with credit for 241 days and orders you to pay your court costs and restitution. And of course, this case will run concurrent with CR 21-0051-392. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court will follow the plea bargain, sentences you to 12 months in a state jail felony facility. You do have 148 days credit and orders you to pay your court costs and lab fee. And of course, this case will run concurrent with CR 20-0489-392. Just a few more things to go over with you, Mr. Gillum. In each of these cases, there was a judgment. I'm showing them to you now. That's the one that has a space for your thumbprint. Did you go over that with Mr. Murphy? In each
Yes,
case?
sir.
In each of those, was your name, the charge, and the time credit correct?
Yes, sir.
All right, and finally, sir, now that you've been finally convicted of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, you need to consult with an attorney. Okay, sir?
Yes, sir.
All right, sir, good luck to you. You're now remanded back to the custody of the Smith County Sheriff for transport to the appropriate authorities to serve out your sentence.
Sir, I have one question to ask.
Yes, sir.
Would my back time credited on there? Right?
Yes, it was.
I'm saying that's time served, isn't it, on the 12 months?
Judge, I'll have an opportunity to visit with him later on this week about all that.
Well, a year is 365 days, Mr. Gillum, and I saw you had 241.
Well, with the other charge, it's 141 credited to it, right?
I don't think it works that way.
Oh, so it's 241?
Judge, I'll have an opportunity to visit with him later on this week about all that.
Okay.
All right, thank you, Mr. Gillum.
Thank you.
Thank you, Judge.
Appreciate you. Yeah. Yeah, you don't get to add them together. Mr. Brown.
Yes, sir.
Your new attorney is John Scott. He's a gentleman right here. Good looking tall fellow right there.
Yes, sir.
Mr. Mills.
Oh, I think we're ready now to do that plea on Mr. Brown.
Okay. Let's try this again, Mr. Bradley. It's a new world. I probably shouldn't be able to tell John Scott that he's good looking. I'm not woke, I guess. Is there one or two pleas? Is there just one plea?
On this case,
Yeah.
there's one information.
And so the indicted case says plea, and then it says.
Right, that's wrong. The indicted case will be dismissed.
I got you. Okay, so I'm just gonna call the new one. That's why I got confused on another one too. You ready? All right. This is cause number CR 21-0415-392, State of Texas versus Robert Lynn Bradley. And this is set today for a plea on information. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Bradley,
We're ready, Judge.
all right, sir, is your name Robert Lynn Bradley?
Yes, sir.
And Mr. Bradley, are you the same person that's been charged by information in this state jail felony offense of attempted tampering or fabricating with physical evidence?
Yes, sir.
I get you to raise your right hand, sir. You solemnly swear or affirm testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Or you can lower your hand. It's that other place. Mr. Bradley, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Bradley, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
And Mr. Bradley, have you ever been treated for any mental health or emotional issues? You answer out loud. I need you to answer out loud.
Have you ever been treated for emotional, anything like that? No, sir.
All right, you understand what's going on in here today?
Yes, sir.
And Mr. Mills, do you believe your client is competent?
I do, Judge.
Court finds that he is competent. Mr. Bradley,
Yes, sir.
first of all, you have not been indicted by a grand jury in this case. Do you understand that?
Yes, sir.
And I know you've got this deal worked out with the state where they would dismiss your indicted case in order for you to plead guilty to this new case. But again, a grand jury has not returned an indictment in that case. In this one right here.
Yes, sir.
And under the United States Constitution and the Texas Constitution, you cannot be held to answer for a felony unless an indictment is returned by a grand jury.
Yes,
Understand that?
Yes, sir.
All right. And of course, that is for the US federal law, but some states don't have grand juries, but Texas does. You understand that? And so you don't even have to be here on this.
Yes, sir.
You want to go forward? And I'm going to get into the rest of the grand jury stuff later, but you want to continue to go forward.
Yes.
All right. And have you seen that information that the state filed against you? That was the written document charging you. Looks like an indictment.
He has, Judge. I showed it to him before we came in here.
And do you need the prosecutor to read it out loud?
No.
But do you understand what it charges you with?
Yes, sir.
All right. Well, that information charges you with a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. However, it's my understanding that this plea bargain you have worked out has a recommendation to the court that you be punished as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in a county jail and a fine not to exceed $4,000. Do you understand those ranges of punishment?
Yes, sir.
In the plea bargain?
Thank you, Judge. As you instructed, it's an attempted tampering, which is a state jail, but we're going forward on the 1244A.
I can't hear. I'm sorry, they're talking, I can't hear.
It's
Go ahead.
80 days county jail on the 1244A on attempted tampering with or fabricating physical evidence. Plus court cost, fees, credit for 84 days. The state will take into consideration through a 1245 letter by the county attorney's office. 2 filed misdemeanors, 2020-0690 CCL1 or maybe CCL2. It's one of the CCLs here in this county. And then the other one is 2020-0691 CCL. It looks like a 2.
They're both 2s, it looks like.
And a criminal mischief that's unfiled misdemeanor. Plus restitution in the amount of $608.25 to Haley Cravey. And we're going to dismiss the previously indicted cost number, which should have already been submitted. This case was also filed within the last 10 days. So we're here with the.
That's all correct, yes.
Is that your understanding of the plea bargain, Mr. Bradley?
I don't understand what this hiding, right?
That was from the county.
Yeah.
You're good.
Is that your understanding, Mr. Bradley?
Yes, sir.
Is that your understanding, Mr. Mills?
Yes, Judge.
And I did write that indicted case on it, the plea paperwork, because it wasn't on them. All right, well, Mr. Bradley, a few minutes ago, you told me you could read and write the English language.
Yes, sir.
I'm going to go over 3 documents with you. The first is the agreed plea recommendation. Did you read and go over that both front and back with Mr. Mills?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Mills?
Yes, sir.
Did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
And finally, and we got into a little bit of this earlier, but the third paper or document I'm going to show you is the defendant's waiver of rights to indictment by a grand jury. Did you read and go over that document,
Yes,
Mr.
sir.
Mills? And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
Well, if you went over that document, I know he explained to you, as I got into a little bit earlier, is that you don't have to do this today on this case because you've not been indicted by a grand jury. Isn't that correct?
Yes, sir.
And do you know what a grand jury is?
Yes, sir.
Well, for the sake of time, I'll explain it to you. It's a body of 12 citizens. They meet in secret and someone presents evidence to them to decide whether or not there's probable cause to believe that you committed this offense in this county. Do you understand that?
Yes, sir.
You don't have a right to be there. Your attorney doesn't have a right to be there or even know it's going to happen. Do you understand that?
I understand.
If more than 9 of those people or 9 or more of those people believe there's probable cause to indict you, then they return an indictment. If less than 9 believe it, then they no bill you. You understand that?
Yeah.
You just want to stop and see if the grand jury will indict you on this new case?
No.
Or do you want to continue on and waive that right to a grand jury?
No.
All right. And then I'll ask you, sir, I know that Mr. Mills explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to waive your right to a jury trial, waive your right to 10 days, and enter into this guilty plea with the state? And I'll ask you, sir, as to that state jail felony offense of attempted tampering or fabricating physical evidence as alleged in the information, are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason?
Yes.
I hear the evidence.
Thank you, Judge. State offers into evidence states 1 and states 2. States 1 is the offense report. States 2 is Martin compliant.
No objection.
Admitted.
Nothing further, rest in place.
Rest in close, John.
All right, then, Mr. Bradley, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the information. The court will follow the plea bargain, punishes you as a Class A misdemeanor under 1244 of our penal code, considers the indicted and filed and unfiled cases that are annotated on the plea sheet, sentences you to 80 days in the Henderson County Jail with credit for 84 days. And there are no attorney's fees in this.
He retained me.
Okay, I just saw it and then marked out. And orders you to pay your restitution to Miss Cravey in the amount of $608.25. And before you go, Mr. Bradley, have you had an opportunity to review the judgment in your case? It's one that's going to have your thumbprint on there. Was your name, the charge, and the time credit correct?
Yeah.
All right, sir, you need to, now that you've been convicted of this felony offense, you're now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, please consult an attorney. You need to see Mr. Halbert to your right. Good luck to you, sir. Yes, sir. Jeffrey Howard. Where's Jeffrey Howard? I guess it's not Jeffrey Howard. Tell him he's free to go. If you did, I gave it to the clerk.
Somewhere.
If you did, it's not on my
It's
desk.
exhibit 4.
And not, oh, you know what? Is his docket sheet in there? Hold on, I'm going to look.
There it is.
It was exhibit 4. There you go.
Thank you.
Mr. Mills didn't object to all that
I
work
know.
product on there.
Jordan Wright, you down. You called him earlier.
We'd call a bunch of.
Probably page 4.
All right, this is cause number CR 19-0338-392, the state of Texas versus Jordan Wright. And this is set for trial docket status today. However, Mr. Wright wasn't here earlier and I issued a capias and forfeited a bond.
Judge, I think he told me what it was. Now I've already forgotten. It was something with his what?
My back brakes were seizing up on my pickup truck. I'm dealing with my back brakes and they're trying to seize up on me on my way here. And I got my 2-year-old wife in there.
Okay.
And they kept trying to grab and on the back ones.
Well, I'm just gonna tell you, there's probably 2 things you don't want to be late for, your marriage, your wedding, and felony court. But you're here, so I'll recall the capias. Any objection?
We'll withdraw. We'll withdraw the bond.
All right, and where are we at then?
Judge, the DA made an offer for 1 year, probated for 1 year to a misdemeanor. And my client wishes to reject that offer and be placed on the trial docket.
What is the? let me see.
Criminal mischief, Your Honor.
Thank you, ma'am. $2,500 or more damage for striking with a bottle?
That's the issue, Judge, whether or not a back windshield costs $2,500. That's one issue.
Okay. No.
Among others, but anyway, my client, when they've made that offer, we've talked about it and he wants to have his right to a trial. So,
Well, and he absolutely has a right. However, based upon the fact that he was late in his appearance, I'm going to order him to take a drug test today. Court deems trial docket status is held. And so you're not giving dates now, are you?
No, he's sitting at number 20, so he'll come up pretty quick.
Come up pretty quick. And actually, I think we're running the docket on the May trial.
Yeah.
We may be able to squeeze him in there.
what day is that?
What day is that?
The announcement's on Monday, and let's see here. Mr. Mills, probably here. And then,
So we'll be out the 12th to the 19th of May. I know that.
we have a trial on the 17th.
He'll be out. So, okay, well, maybe we'll get him next time. But anyway, Mr. Wright, so you will receive a reset, you'll receive notice of your next court date. We don't have those now. But I'm going to order you to take this drug test. When you're finished, come back in the courtroom and we'll all go over the results together.
Thank you, Judge. That's all I have. Thank you.
Sure, we'll let you know if we need you or you want to stick around or,
Well, I'm actually supposed to be somebody at 3 at the office, so
yeah, we'll let you know. Let's see. Mr. Stevens,
Page 6, Your Honor, Dylan Baker.
be for a plea, Your Honor.
let's see, I got two. I need to have Alexander Height and Jessica Estes sitting in the jury box, please. Same thing with Alvis Waters, the jury box, please. Dylan, I'm trying to do too much multitasking. I'm done with that one. I'm not with these yet. Mr. Strawn, you ready on the plea?
Oh, Mr. Baker, yes, sir.
Okay. All right. This is cause number CR 20-0643-392, State of Texas versus Dylan Andrew Baker. And that is actually set for discovery status. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Baker,
Defense is ready.
sir, is your name Dylan Andrew Baker?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes.
All right, if I can get you to pull that mask down. There you go, that way I can hear you. Raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And you can lower your hand. Mr. Baker, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Baker, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes.
Mr. Stevens, do you believe your client is competent?
Yes, sir.
The court's going to find he is competent. Mr. Baker, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days and more than 2 years in a state jail felony facility and a fine up to $10,000. Do you understand that range of punishment?
Yes, sir.
And Mr. Strawn, the plea bargain?
Your Honor, it's 180 days under 1244, plus attorney's fees, court costs, and 180 lab restitution to DPS. The state will take into consideration an unfiled penalty.
And credit for 80 days?
Yes, Your Honor.
Right. Is that your understanding of the plea bargain, Mr. Baker?
Yes, sir.
Is that your understanding, Mr. Stevens?
Yes, sir, it is.
Well, Mr. Baker, a few minutes, I did go over the Class A range of punishment, didn't I? Let me go over that. It's my understanding also, based upon the plea bargain, that the state is requesting that the court punishes you as a Class A misdemeanor in exchange for your guilty plea. A Class A misdemeanor carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. You understand that range of punishment?
Yes.
Okay. All right. Well, Mr. Baker, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 of these documents here. The first is the agreed plea recommendation. Did you read and go over both front and back of that document with Mr. Stevens?
Yes, sir.
And did you sign the front and back?
Yes.
Have any questions about it?
No.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages?
Yes.
And did you sign the second page?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you went over with Mr. Stevens?
No.
Well, if you read and went over these with Mr. Stevens, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No.
You want to waive your right to a jury trial and enter into this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence states 1, 2, and 3. Stage 1 is the offense report. Stage 2 is Morton discovery compliance. Stage 3.
No objections.
Admitted.
Rest in court, Your Honor.
Defense rests in plug, Your Honor.
All right, then, Mr. Baker, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will follow the plea bargain, punishes you as a Class A misdemeanor, considers in punishing you the unindicted bail jumping and failure to appear case, sentences you to 180 days in the Henderson County Jail with credit for 80 days, and orders you to pay your attorney's fees, court costs, and lab fees. We've got a few more things to go over with you, Mr. Baker. First, did you see this agreed judgment and go over it with, this judgment and go over it with Mr. Stevens?
Yes, sir.
And was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney.
Yeah.
All right, you're now remanded back to the custody of the sheriff to serve out the remainder of your sentence. Good luck, sir. You need to see Mr. Halbert to your right, right over here.
Good luck.
Yes, sir. Appreciate
Thank
it.
you, sir.
The younger Mr. Stevens.
Your Honor, middle of page 6, June Howell.
June Howe. Yeah, see the back of the sheet. All right, this is cause number CR 21-0050-392, the state of Texas versus June Howe, set for discovery status.
Discovery has been provided, Your Honor. There's currently 2 offers. One is for probation and the other one is for county.
And Your Honor, we did just receive some discs this morning. I haven't had an opportunity to compare them against the offense report, but I anticipate we have all the discovery.
Okay.
If there's something, I'll bring it to the state's attention and. we'll
Yes,
get it
sir.
resolved.
And then we can reconsider another date. All right, then, Ms. Howe, the court deems discovery status is held. Your next court date is June the 2nd at 1:30 for pretrial. However, based upon the nature of your charge, I'm ordering you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together. Thank you, ma'am.
Thank you, sir.
Did that one just get put up there? Christopher Thompson. Have a seat in the jury box. Who else you got?
Kelly Jackson, Your Honor.
Kelly Jackson. Just tell me they're taking a drug test before. Okay. All right, these are cause numbers CR 21-0006 and 0007-392, both styled the state of Texas versus Kelly Jackson, and both set for discovery status.
Discovery has been provided in both causes, Your Honor. The agreement or the offer was, not the agreement, but the offer was for probation or county jail time, either on one or the other in TIC.
Any discovery issues, Mr. Stevens?
Again, Your Honor, I received some discs today. I anticipate I've received everything. And so at this point in time, we'll deem discovery status held.
Okay. All right, Ms. Jackson, the court deems discovery status is held. Your next court date is June the 2nd at 1:30 for pretrial. However, before you go, I'm going to order you to take a drug test. You're going to go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together, okay? Don't leave until we talk.
Okay.
All right, thank you, ma'am.
And James Kirkendall.
James Kirkendall. All right, these are cause numbers CR 21-0045, 46, and 47-392, and all are styled the state of Texas versus James Kirkendall, and all set for discovery status.
Your Honor, the discovery has been handed over to Mr. Stevens along with a 10-year TDC offer.
That's correct, Your Honor.
Any discovery issues?
No, no, sir.
All right, then, Mr. Kirkendall, the court deems discovery status is held. Your next court date is pretrial, and that is on June the 2nd at 1:30. Okay, sir? All right, so if you get out of jail between now and then, I need to see you on June 2nd.
Your Honor, my others are going to be pleased. I'll circle back around.
Sure. Thank you,
Thank you.
sir. Ms. Altier? Mr. Height, come on up. May I see the docket sheet on him again? I'm sorry. All right, this is cause number CR 21-0010-392, the state of Texas versus Alexander Height. Mr. Height was ordered to take a drug test based upon the nature of his charges, and Mr. Height had previously tested positive for methamphetamine and amphetamine on March 23rd. Today, his drug test indicates positive again for meth, amphetamine, and THC. And so the court's going to find his bond insufficient. What is, so his new bond is $17,000 surety bond.
Your Honor, may I speak?
Yes, ma'am.
Mr. Height tells me that he is adamant that he has not had any of these drugs. He has not taken these in never marijuana or THC and the methamphetamine for several months. He's requesting the court to let him retake his urine test right here in the lab, if the court would consider that.
Well, I think the test that he gave earlier was insufficient. And so we couldn't even send it off. Is that correct? It was not even enough to send off to the lab.
That is correct.
Well, if he could retake, you feel like you could, if he could just retake it again, he's requested that I ask the court.
We'll use the same cup. We're just gonna use the same cup, because we provide more samples to send out to the lab. Not gonna do the same cup we get sealed.
Yeah, I mean, the fact that it's, you know, the same thing that was the last time, which was March. And here we are in May. And so I'm going to respectfully deny that request. Bond will be $17,000 surety bond. So you'd have a seat in the jury box, sir.
I have nothing further. May I be excused?
Yes, ma'am. Thank you.
Thank you.
Here's his drug test. Mr. Scott. Miss Estes, come on up. I'll need to see her doc sheet. Anybody seen Mr. Regano? All right, this is back on the record in cause number CR 21-0013. Yep. -392, the state of Texas versus Jessica Marie Estes. Based upon the nature of Ms. Estes' charges, she was ordered to take a drug test. Ms. Estes apparently has tested positive for methamphetamine, amphetamine, and THC, and admitted apparently to probation that is that a 5/2/21
Yes, sir. Sunday.
on Sunday to
Yes, sir.
smoking meth and marijuana.
Yes, sir.
All right, well, Ms. Estes, this is your first time to test positive, and so the court gives everybody their one free chance. And so I'm going to place conditions of bond on you if there's not already conditions. There's not. So you're going to be no marijuana, no drugs not prescribed, no illegal drugs, and that includes, well, I said marijuana, and no alcohol. And so it kind of looks to me like you're still under the influence, like you've been up for a few days and you're fixing to crash on me here.
Oh, no, sir. I've been at work this morning since 4:30.
Exactly. I know how this works. And so, ma'am, I'm going to tell you that in June, you're subject to be tested again. If you test positive, it'll be your second time, and I can't promise you you'll go out that door. You may go out that one. If you need help, ask. There's lots of programs out there. All right. And so as soon as you receive those signed bond conditions from me, ma'am, you're free to go, and we'll see you in June.
I'll get it to you. Just see. I'll get it to you sometime.
Here and there.
And Ms. Thompson, I'm going to bring you back in real quick for, did you have another one?
I've got a plea, but I think Mr. Strong wants to.
Okay, let me handle Mr. Thompson. Mr. Thompson, come on up, sir. On the docket sheet. It's cause number CR 20-0641-392, the state of Texas versus Christopher Thompson. Mr. Thompson, Ms. Thompson, you got me?
Yes, sir.
Yes, sir, I'm there.
All right, and Mr. Thompson, you were ordered to take a drug test based upon the nature of your charge. It appears as though you have tested positive for THC, meth, and amphetamine. And again, sir, like the lady previous to you, this is your first time. Give everybody their one free chance.
Yes, sir.
You already have conditions of bond that you might not have known about. And so your conditions of bond are you're to abstain from using alcohol, illegal or controlled substances that are not prescribed, and that includes marijuana, no marijuana. And so again, like I told the lady before you, I'm going to drug test you in June, and if you test positive, you may not go out that door, you may go out that one. Do you understand? Right, and so here is a sign. Is that his? This is for you. Ms. Thompson, for the record, I'm handing him a copy of his bond conditions signed by me. And so with that, unless you got something else for him, do you?
No, sir, I don't. I'd just like for him to give me a call in a couple of days.
Mr. Thompson, you heard that, and we'll see you in June. You're free to go, sir.
Your Honor, that's all I have this afternoon, may I have
Thank-
excuse, sir?
Yes, ma'am. Thanks for hanging around. Still have Alvis Waters. Who is the attorney? I'm gonna go through the doc. On the Alvis, let me just see it first, the docket sheet. Do you want to text Steve, see if he wants to pop in? Mr. Waters, we're gonna text your lawyer, not instead, we're gonna text your lawyer so he can come back up if he wants to. All right, ladies and gentlemen, what I'm gonna do now is, looks like we're at a standstill, so I'm gonna go through the docket. If you hear your name called, just let me know you're here. You don't have to come up. Tammy Light. Miss Light, have you talked to Mr. Regano?
Yes, sir. He's in trial and wants you to reset it.
Well, he needs to answer the coordinator's emails, or we would have reset it and you wouldn't have had to be here today.
Right?
Exactly. So
I did talk to him.
explained to him that almost that we take the case off the docket because he wasn't sure if he was gonna go to trial.
Gotcha.
So he asked to, if we reset in July, it's June second.
What day in July?
July, so what we gave. Randy,
July 7th.
July 7th at 9 o'clock.
All right, ma'am, I'm going to reset your case for July 7th at 9 a.m. All right, so the prosecutor will give you a reset notice, or one of their people will. Can we get her a reset notice for July 7th at 9 a.m.? And ma'am, as soon as you receive that, you're free to go. And that is CR 18-0025-392, State of Texas versus Tammy Light. Mr. Anderson, Gary Wayne, gotcha. Mr. Scott's right there. Jason Willingham,
Yes, Your Honor, he's for a plea.
is he here?
Have to do one more form, but we're pretty close.
Is he here?
Yes, he's outside.
Okay. I'm just going through the docket, seeing who's here. Keith Gleason, Mr. Stevens' client. Thank you, sir. Dennis Neal. Dennis Neal. Brian Nichols. Brian Nichols. Eric Passmore. And then the last one is Michael Holsey. I got you, sir. And Mr. Holsey, who's your attorney?
Brad Stevens.
Okay, he's out in the hallway then. Are we ready on anything? If not, I can take a break, doesn't matter.
Willingham, I believe, Your Honor.
Willingham?
He's sitting right out in the.
Is this Miss Estes?
Can he come on up, Your Honor?
Yes.
Just stand right there in front of the bench. Make sure you speak up, because that glass, they can hardly hear.
Jordan Wright. Who's Jordan Wright?
Judgment only talks about court costs.
When we get him, I need him to have a seat in the jury box. I've got him coming in now, don't
It's not on the judgment, so the judgment's what controls.
I don't have a paper yet. I'll just say. Is he coming? Mr. Wright, have a seat in the jury box. Trying to keep it all straight. Do we have any more coming in? I'm not in a big hurry, Sandy, don't you? Taking a little break here. Y'all got more over there? That stuff everywhere here. I don't know. Yeah, I'm still waiting. On that one. sir. That's all I needed to. Who did he have? Who says? Mr. Wright? Alice Waters? Okay. Do you mind if I just handle this one real quick?
Not at all.
Right, we're still working on paperwork, so y'all just want to back up a second. You don't have to go all the way back. Mr. Waters? Mr. Green was your attorney, is that correct?
Yes, sir.
All right, can I see the docket sheet on Mr. Waters? All right, this is back on the record and cause number CR 21-0025-392, State of Texas versus Alvis Waters. And Mr. Green, it appears as though Mr. Waters has tested positive for methamphetamine. And this is his first time, at least in this court, of tested positive. So Mr. Waters, you get one free shot with me. And so like I told those other individuals, you now have conditions of bond, and they are as follows: no alcohol, no marijuana, no illegal drugs, and no substances that are not prescribed. You understand?
Yes, sir.
And I'm going to test you in June when you come in. If you test positive, you may not go out that door. You may go out that one. Okay? All right, sir. As soon, go ahead and have a seat in the, do we have his conditions of bond yet? All right, you're going to, as soon as you receive my signed conditions of bond, you're free to go. Anything, Mr. Green?
No, Your Honor.
Okay, thanks for coming back in.
You bet.
Don't
Thank
leave until you
you.
get those signed conditions, though, sir.
Thank you, Judge.
Thanks, Steve. All right, y'all can come on up. I think I'm ready now. That's Mr. Waters. Finish with him. This is cause number CR 21-0004-392, State of Texas versus Jason Wesley Willingham. And that was originally set for a thought I had it. Discovery status hearing today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Willingham,
Ready, Your Honor.
all right, sir, is your name Jason Wesley Willingham?
Yes, sir.
And are you the same person that was originally indicted for the second-degree felony offense of manufacture and delivery of a controlled substance?
Yes, sir.
I can get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
You can lower your hand.
Your Honor, there was a third degree paragraph too, and that's, I think, what we're going on, because it's being reduced to state jail.
The indictment currently is a first and second paragraph A and B, where abandoning enhancement, going on the lesser paragraph B.
Right, okay.
Let me just ask you this way, Mr. Willingham, are you the same person that was charged with this felony offense?
Yes.
All right, and I just swore him, is that correct?
Yes.
All right. All right, Mr. Willingham, can you read and write the English language?
Yes, sir.
Are you a US citizen?
I am.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And I got to ask that everybody. Mr. Willingham, can you read? I just asked you that. Have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today? And Mr. Scott, do you believe your client is competent?
He is, Your Honor.
Court finds that he is competent. Mr. Willingham, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in our courtroom?
No.
But do you understand the charge?
I do.
Well, as indicted, so it's 1 to 4 in the
It's a
body.
second and third degree enhanced to the first and second degree punishment range.
Okay, so it's 1 to 4 with intent as originally indicted, which would be a second.
Yes, and then there's an
All
enhancement.
right, so we'll handle it that way. Mr. Willingham, without any enhancement paragraphs of any allegations of prior felonies, this charge would be a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice. and a fine not to exceed $10,000. You understand that range of punishment?
Your Honor, am I wrong in saying that the paragraph B is between one and without possession? So without
What's he pleading
enhancement, that would
to?
be a third
He's-
degree.
He's pleading with paragraph B.
Oh, well, y'all got it marked a second degree on the plea papers. That's what's throwing me off. And I see way up here, you're banning paragraph A. That's what confused me. Just,
It's a manner of means. It should be probably counts under, but it's block murder. So it's a paragraph.
I understand. No, that's the way we always used to do it. I just saw the second degree, so that's what I went with. All right. Mr. Willingham, let me go back.
Yes, sir.
There are two paragraphs in the indictment. It's my understanding that we're going to go on paragraph B with this plea bargain. If paragraph B, that felony is a third degree felony, which carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice. Do you understand that?
Yes, sir.
However, it's my understanding that the state is willing to abandon any enhancement paragraphs and allow you to plead to the lesser included offense of that in paragraph B, which would be a state jail possession of a controlled substance. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand both of those ranges of punishment in the plea bargain in the case?
Yes, Your Honor. It is 9 months state jail. On that state jail felony offense in paragraph B, the lesser, a credit for 270 days plus court cost.
That your understanding of the plea bargain, Mr. Willingham?
Yes, it is.
Is that your understanding, Mr. Scott?
It is, Your Honor.
And Mr. Willingham, a few minutes ago, you told me you could read and write the English language. I'm going to go over two of these documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Scott?
Yes, I did.
And did you sign it?
Yes, I did.
The next document I'm going to go over with you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr.
Yes, I did.
Scott? You gotta wait for me to completely ask the question.
Yeah.
It's okay. And did you sign the second?
Yes, I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you went over with Mr. Scott?
I did not.
If you went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir, no.
Do you want to enter into this plea bargain?
Yes, I did.
And I'll ask you, sir, how do you plead to paragraph B? How do you plead to the lesser included offense, a state jail felony of that which is charged in paragraph B? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence states 1, 2, and 3. 1 is the offense report, 2 is Martin discovery compliance, and 3 is the lab report.
No objection, Your Honor.
Admitted.
Rest and close, Your Honor.
Senate rest, Your Honor, and closes.
All right, then, Mr. Willingham, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense, a lesser included of the offense charged in paragraph B. The court follows the plea bargain. Grants the request to abandon the enhancement paragraph, sentences you to 9 months in state jail. However, you do have credit for 270 days and orders you to pay your attorney's fees, court costs, and lab fees. And just a couple more things to go over with you, Mr. Willingham. Have you had an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, it is.
And finally, sir, now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. Good luck to you, sir. You need to see Mr. Halbert to your right.
All right, thank you, sir.
That's easy. You were
Might have been
throwing
easier
me
to go
off
through
'cause
there.
you kept looking at the plea sheet and I thought, where am I?
It was very.
Yeah.
Oh, Mr. Caffey, where's he go? Okay, they did recall it. Did he take a, did I order him to take a drug test too?
He did, Your Honor. We have the results now.
Okay. Mr. Scott, do you have something else? Sorry, you're
Bond
standing.
reduction hearing, Your Honor. Shouldn't
Okay.
take too long.
What is that, what are we doing on, look, can I handle this one before we get into a hearing? Are you good or do you want to go? Yeah. Do we have his yet? All right, this is back on the record and cause number CR 21-0042-392, the state of Texas versus Walter Cathy. First of all, Mr. Cathy, it looks as though they've recalled the capias they had, so I'm not going to place you in custody on that. I did order you to take a drug test. You tested positive for methamphetamine, amphetamine, and THC. And Mr. Cathy, so you get one free shot with me in here. And so I'm going to place you on bond conditions, no alcohol, no marijuana, and that includes THC, gummies or whatever it is. I should start saying it. And no illegal drugs or drugs not prescribed. So as soon as you receive the signed by me copy of your bond conditions, you're free to go and I'll see you in June. Well, go. You ain't got them yet.
Let me get these to you.
Thanks for sticking around, Mr. Head. That is Mr. Cathy. June Howe. Have a seat in the jury box, ma'am. Kelly Jackson. Kelly Jackson, you're free to go. See you in June.
Thank you so much.
All right, Mr. Scott, you ready? Sorry.
Yes, no problem. Gary Anderson, Your Honor.
I need to get that back to you. All righty, this is cause number CV 21-0175-392, ex parte Gary Wayne Anderson. And that is set today for a writ seeking bond reduction. Is the applicant ready?
Is he what?
Ready?
Oh, ready. Yeah, sorry. I thought you said, is he out of jail?
No, I can tell he's not. He's right
Not
there.
yet.
Unless he likes to wear orange and wear handcuffs. And on behalf of the state.
State's ready.
All right, and are we going to hear testimony from your client for the limited purpose of bail?
That's right, Your Honor.
Mr. Anderson, if you can raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Scott.
You're Gary Anderson Jr.
Yes, sir.
And Gary, you're in the Henderson County Jail for a charge of unauthorized use of a motor vehicle. Is that correct?
Yes, sir.
And you've got a bond in the amount of $35,000 holding you there, right?
Yes, sir.
And you also in jail, you've got a charge out of Wichita Falls or Wichita Falls County,
Yes, sir.
Wichita Falls, Texas. And that's a $10,000 bond. Is that right? Is that right?
Yes, sir.
Okay. You're unable to make any of these bonds.
Correct.
You thought you might be able to come up with a little bit of money to try to reduce this bond too, but that fell through.
Right.
You don't have any bank accounts, you don't have anything you can sell, no way of making any money to make a bond.
No, sir.
If the court did give you a PR bond, which is what you're asking for, you'd still have a hold on you from Wichita Falls County.
Yes, sir.
You can't make bond on that, so you'd have to go there and deal with that case.
Yes, sir.
And you understand that?
Yes, sir. That's the purpose.
That's what you'd like to do.
Yes, sir.
Do you feel like where that case is in the stage of things is far more progressed than this one, and you might be able to deal with that one quicker? Is that
Actually, they're running at the exact same time. I've already got a lawyer up there and everything, but they can't do anything with me still in this county. That's why with the bonds.
Can you pull that mask down?
Yeah, with the bonds, I can't place it out of county bond. So
okay? So if I understand what you're saying, just make sure we're on the same page. You feel like you've pretty much already got something worked out there. You just need to get there to do it. You've already got a lawyer.
yes, sir.
Okay. Once you got done with that case, would you feel like you'd be going to TDC or would you be time served situation?
I believe it would actually be PR bonded on June 2nd, which would be my 90-day right along with this one. And then
Okay.
I'd be coming back here to 7 Points, Texas.
You live and you've lived in 7 Points for several years.
Yes, sir.
You were born there.
Yes, sir.
And I think you told me you had a job lined up when you get out.
Yes, sir.
And what is that?
Working at a neighbor's tire on 274 out in Kent.
You you worked there before?
Yes, sir.
And you've talked to the boss and he's ready for you?
Yes, sir. That's,
On
working
274, is that what you said?
Yes, sir.
Okay.
So you're asking the court to grant you a PR bond. How long have you been in jail? I forgot to ask you that.
March 3rd.
Okay. And then you'll go there and then you promise to appear for any court settings that you'll have here and you'll get in contact with me when you get back.
Yes, sir.
Okay. I'll pass the witness, Your Honor.
Mr. Strong,
I have no questions for this witness.
any alleged criminal history?
I do, Your Honor. There's prior convictions that we show to be a misdemeanor theft out of Smith County, theft misdemeanor out of Dallas County, forgery felony conviction out of Wichita County, also an unauthorized use of motor vehicle, felony conviction out of Kaufman County. We already discussed the pending possession, which is a felony of a controlled substance, Wichita County, and we show a pending case out of Oklahoma. It's a felony flight from Texas.
Is it against the law to flee Texas?
I guess so.
I guess Oklahoma don't want us coming up there.
What is that?
We need to shut down the casinos.
I've never heard nothing about that.
Yeah, my client's unfamiliar with that charge, Your Honor. He does, I'm not sure what that is, so he looks a little, that may be the first time he's
Is that
heard
in
he
their
had
penal
that.
code, flight from Texas?
Flight from Texas, so it sounds like they have a flight risk with
Understood.
the applicant.
All right. Anything else?
Nothing further from the state.
No, Your Honor.
All right, well then respectfully, the motions to reduce bond are denied and bond will remain at $10,000 surety bond in each case. Or 35, sorry,
35,000.
wherever they are. It's, I'm looking at the wrong, $35,000 for the unauthorized use of the vehicle.
Yes, sir.
Thank you.
Thank you, Judge.
Yes, sir.
And that's all I have, Your Honor. May I be excused?
Yes, sir. Thank you. Mr. Stevens.
Yeah, bottom of page 8, Eric Passmore.
Get these in light. I should have done what I normally do, had all the drug test people go earlier. I just didn't think about it. All right, this is cause number CR 20-0668-392, the state of Texas versus Eric Passmore, set for discovery status.
Discovery has been provided, Your Honor. There's currently, so maybe there was one offer for time served in this case.
In Your Honor, we have received the discovery. I haven't had an opportunity to discuss that offer with my client. I believe it may have come with the discovery I just recently received, but I'll discuss that with them today. And if we can circle back around to resolve it, we may do that. If not, we'd ask just to pass it to the next thing.
Well, if he does it today, I'm not going to drug test him, but if he does, and I'm not trying to pressure him either way, I'm just saying.
Your Honor, I believe we've got a plea worked out.
Okay, I mean, it's 3 o'clock. And so, all right, well then, Mr. Passmore, I'm going to recall your case. All right, so just go ahead with your attorney. You got some other stuff?
Yes, sir. On the very last case on the docket is Michael Hulsey. I've been retained to represent him.
Michael Hulsey. These are cause numbers CR 20-0678 and 79-392, both styled the state of Texas versus Michael Hulsey, and both set for discovery status.
And Your Honor, I don't believe the state was aware that I was retained until today. If we could have another discovery status, we'll get all the discovery together.
You all right with that, Mr. Hulsey?
Yes, sir.
All right, then I'm going to reset your case to June the 2nd at 1:30 for discovery status. And stay in touch with your bondsman and your lawyer. We'll see you back in June.
Yes, sir. And Your Honor, we can go back to the top of my cases. The rest of those are going to be pleas. I
So
believe
hold
Dennis
on, let me just
Neal-
go through. Neil's going to be a plea
Neal's a plea.
and Nichols.
That's a plea.
Okay, and then the last one is a plea.
Yes.
Gleason.
Gleason's a plea.
Okay. And let's see, who have I not dealt with? That's Ms. Howell
I believe my client, your honors.
All right, Ms. Howe, come on up. This is back on the record in cause number CR 21-0050-392, State of Texas versus June Howe. And Ms. Howe was ordered to take a drug test, and it appears as though she's tested positive for methamphetamine and admitted to smoking it on April the 28th. Ms. Howe, you're on bond, and now I'm putting you on bond conditions. And so this is your first time. Everybody gets their first time with me. No alcohol. These are the conditions of bond. No alcohol, no drugs, no marijuana or THCs, gummies, whatever. No illegal drugs and no drugs not prescribed. And so as soon as you receive those bond conditions in writing, you're free to go. I'll see you in June. If you need help, ask somebody. Because if you come in June and you test positive, I can't promise you you'll go back out that door. You understand? Thank you, ma'am. I've got them right here.
Yeah.
As soon as she signs, she can go.
Yes, sir.
Ms. Howell. And then we still have Jordan Wright. Did I handle Jordan Wright? He did. Can I see Mr. Rice? Mr. Wright, I've never drug tested you before, have I? All right. Here's what I'm gonna do. Your attorney's in an appointment. I'm gonna do with you the same thing I did to those other two. Do you want me to wait and have you continue to sit over there until we can get your attorney? Or do you just want me to put you on conditions of bond without your attorney and let you go? You have a right to have your attorney here for this.
Oh, just.
All right, well, here's what I'm gonna do. This is cause number CR 19-0338-392, the state of Texas versus Jordan Reed Wright. Mr. Wright was late to court today. I ordered him to take a drug test. He has tested positive for THC. Mr. Wright, I'm going to place you on conditions of bond and actually admitted to smoking Delta 8. I don't know what that is.
At the head shops. It's.
I'd kind of, if I was on felony bond, I'd kind of stay away from head shops if I were just on a suggestion. So I'm going to place you on conditions of bond. No THC, including gummy bears, Delta 8, whatever. No drugs not prescribed, no illegal drugs, and no alcohol. You understand? So you're going to receive those conditions of bond in writing. Once you receive those in writing, just make sure you call Mr. Mills, leave him a message. He knows what's going to happen, and I'll see you back in June. But don't leave until you get those written conditions of bond. All right, so you can have a seat out there if you can get them. Yes, sir. Thank you. Do we have any more drug tests outstanding? That's everybody? You good, or you want to break? All right. Unless you got something quick, Mr. Stevens, that'll give you a chance to get all those pleas ready. We're going to take a 15-minute recess, so we'll reconvene at 3:30. Thank you.
Yeah, I agree. Yeah, I was just curious how the process works. It just doesn't like, I assume it's very. Sometimes it's in my house. Yeah, I'll register. I think Samantha. The 21, the ones that we guys on our mind. I'm changing this. You think that's maybe you're like, and and then, oh, okay.
Ran off and got that. Started outside. They called, talked to Yeah, yeah. One day, because of circumstances, it's not. So it's not, you know, That's the real bad, but judge knows it's the problem. Yeah, he sent me a text message with his, I said, well, I said, probably get to the on-time service, so let me make sure.
Well, our notes say.
Okay. It would be also one day. They don't care.
We may be here. Oh, I don't know. Oh, we did this.
Did you send it?
And as she shared it with me, she didn't.
She knows. That's what.
No, it is, yeah. She might be from her parents live in the corner now. I took their Christmas pictures. Yeah, that's true. Not that kind of photography. We don't roll too much. So, this is- That's the one I showed you. I think it's that.
There you go.
Yeah. Got her. It's more tropical, like fruit. But you got, St. Lucia and St. Peter's are across from, berries and things like that. We want fruit, all over down there. We went there. Yeah.
I think if you keep watching.
I'll file it right. I'm gonna file it right away after.
Everybody say the thank you. All righty. Continuing on with the 1:30 docket, Mr. Stevens.
Sharon, if we could just go down the docket, they all please ask more, they're driving this last section of the paperwork. so let's do that.
So Stevens, I guess, or Stevens, you're Stevens. Gleason would be first.
Yes, sir.
All right, this is cause number CR 20-0280-392, the state of Texas versus Keith Leon Gleason. And this one's actually set for a plea today, is that correct?
Yes, sir.
Is state ready?
State's ready, Your Honor.
And on behalf of Mr. Gleason?
We're ready.
All right, sir, is your name Keith Leon Gleason?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of assault family violence?
Yeah.
I can get you to raise your right hand. Sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Gleason, can you read and write the English language? You gotta wait for me to finish it because she can't take two people talking at once. Is that a yes?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Gleason, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be? Were you ever diagnosed with anything?
I thought I was diagnosed bipolar, but I don't know.
You don't know? Are you on any medication?
Prozac.
Okay. All right. And are you taking that as prescribed?
Yes, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds he is competent. Mr. Gleason, I know that we have already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
If you understand the charge.
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
Why does it say second on your indictment?
I think it's assault family violence with a prior conviction.
It does.
I didn't catch that. I apologize, Your Honor.
So he's pleading to the second degree. First, I mean, because that's a big deal if he's adjudicated and revoked. We're talking a difference of 10 years there.
Yes, sir.
So what are we doing? Third or a second? Because if he pleads to a third, I don't know what y'all bargained for. If you bargained for a third, he can plead to the lesser included.
It was bargaining for a third.
My understanding is it was pleading as indicted. If we want to take a break, we can get clarification.
Yep, y'all need to figure that out because if I take his plea, it's a second degree and then he can say, hey, that's not what he bargained for because it's check third degree. Y'all need to talk real quick?
I'd rather take a break and just double check and make sure.
Yeah, I was dealing with Laura on this case, so we'll get with her and confirm.
So here's what I'm going to do. I'm going to recess the case. And then Mr. Gleason, I'm going to take care of some other business with Mr. Stevens and then we'll allow them to talk. So I hate to ask you to wait, but you're going to have to wait some.
Yes, sir.
Thank you, Judge. Sorry.
That's why I started looking at the indictments. I knew it just didn't look right to me. Next, we have Dennis Neal. They talked to me about it.
I think we're gonna text Laura to come in and I'll visit with her if we want to go to the next one.
Let's go to the next one and then that way we don't have your
Yes,
folks
sir.
sitting here waiting and we can get probation with them and get them going.
If we're ready for Dennis Neal.
All right, Dennis Neal. This plea on information dismissed the indicted case.
Yes, sir.
All right, this is cause number CR 21. Sound like I was from New York there for a minute. Cause number CR 21-0413-173. The state of Texas versus Dennis Lee Neal. And this is set today for a plea on information. Is the state ready?
It's ready.
And on behalf of Mr. Neal,
We're ready.
right, sir, is your name Dennis Lee Neal?
Yes, sir.
And are you the same person that this information's been filed on for the second degree felony offense of injury to a child or disabled person?
Yes, sir.
I'll get you to raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I do.
You can lower your hand. Mr. Neal, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Neal, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Neal, to start off with, in this case, you have not been arraigned because you have not been indicted by a grand jury. Do you understand that?
Yes, sir.
And the Texas Constitution guarantees you that you cannot be held to answer to a felony case at trial unless and until a grand jury returns an indictment. Do you understand that?
Yes, sir.
Do you want to keep going with this today?
Yes, sir.
All right, well, that information charges you with a second degree felony. A second degree felony carries a punishment range of not less than 2 years, nor more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, the state recommends on the second degree injury to a child, 10 years, TEC probated for 5 years, with time credit for 19 days as of today, $1,200 in attorney's fees, $305 in court costs, $50 to Child Advocacy Center, $50 to Crime Stoppers, drug testing, GED within 24 months, 400 hours of community service, the sex offender program and conditions, the complete substance abuse evaluation, and to abide by the terms of the agreed lifetime protective order for the victim.
Is that your understanding of the plea bargain, Mr. Neal?
Yes, sir.
And it says your understanding, Mr. Stevens?
It is, Your Honor, but the attorney fee should be $1,250 under the standard fee schedule, but that is my understanding of it.
I changed them on the plea papers. Any issue with that?
No, Your Honor, that's fine. Thank you.
And as part of that plea bargain, the complaining witness, can we put on the record that agreement or situation with the complaining witness?
I'm sorry, Your Honor.
The victim?
Yes, they are on board. The family's on
Okay.
board with it.
You might, did you say that?
I did not.
Okay,
Judge.
I
I
just
just couldn't hear you.
All right, that's right. I hate this class. All right, and so Mr. Neal, that's your understanding of the plea bargain. And Mr. Stevens, that's your understanding.
Yes, sir.
Well, Mr. Neal, a few minutes ago, you told me you could read and write the English language. I'm going to go over 3 documents with you. The first is the agreed plea recommendation. Did you read and go over both front and back and sign the front and back with Mr. Stevens?
Yes, I did.
Do you have any questions about it?
No.
The second one, or document I'm going to go over with you, I kind of touched on it just a few minutes ago, but it's the defendant's waiver of rights to indictment by a grand jury.
Yes.
Did you read and go over that with Mr. Stevens?
Yes, I did.
And did you sign it?
Yes, I
Do
did.
you have any questions about it?
No, I don't.
Well, if you read and went over that document, I know that Mr. Stevens explained to you that what I explained to you earlier is that you don't have to do this today. You understand that?
Yes, sir. I understand.
All right. Now, I know that they're dismissing another case in exchange for you doing this, but this is just an information. You understand that?
Yes.
A grant and an information is nothing more than a piece of paper alleging that you committed some offense signed by an assistant district attorney. You understand that? All right. You actually have a right to have a grand jury hear this case. And a grand jury is 12 people that meet in secret and decide whether or not there's probable cause to believe that you committed this offense. Do you understand that?
Yes, sir.
If 9 or more believe there is, then they can return an indictment. If less than 9 believe that, well, then this would be no bill. Do you understand that?
Yes, sir.
Do you want to wait and see if a grand jury will indict you on this?
No, sir.
Do you want to waive your right to a grand jury and continue on with this plea bargain?
Yes, sir.
Well, then finally, sir, the last document I'm going to go over with you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over that document with Mr. Stevens?
Yes, sir.
And did you sign it?
Yes.
Do you have any questions about it?
No, sir.
Well, if you read, and went over all these documents with Mr. Stevens, I know that not only did he explain the grand jury situation with you, but he also explained that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that second-degree felony offense of injury to a child as alleged in the information? Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
State offers Exhibit 1, a copy of the offense report, Exhibit 2, the initial inventory report, and Exhibits 3 and 4, supplemental inventory reports.
No objection.
Admitted.
State resting closure, Your Honor.
Rest and close as well.
All right, Mr. Neal, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense of injury to a child. The court reluctantly follows the plea bargain. I got to tell you, if this weren't for the COVID situation we're in, I may not. I don't know. But however, the court then follows the plea bargain, sentences you to 10 years, in the Texas Department of Criminal Justice. However, the court will probate that for 5 years, places you on community supervision, orders you to pay your attorney's fees, court costs. You do have a time credit of 19 days as of today to any sentence you may eventually have to serve, and orders you to abide by all the regular and special terms and conditions of community supervision, including that lifetime protective order. And Mr. Neal, have you ever been on probation? You
Yes,
either
sir.
know you have or you
Yes.
don't.
Yes,
You
sir.
have.
Well, about 30 years ago.
All right. And did you successfully complete it?
Yes, I did.
You know what can happen if you don't successfully complete this?
Yes, I did.
What can happen?
Go right to jail.
For how long?
Probably 10 years or 20 years.
Up to 10, actually. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be held with no bond, brought back before the court. If the court found you'd violated even one term or condition in this community supervision, the court could revoke your probation and sentence you to 10 years in prison. You understand that? So would you agree with me? It's extremely important you abide by these.
Yes, I did.
I hope you do, sir. Good luck to you. You need to see Mr. Halbert to your right. And then you need to see the probation department. And one thing I forgot to go over with you is now that you've been found guilty of this offense, you're now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult with an attorney. Thank you, sir. Mr. Halbert, and you'll need to see probation. You're handling some cases today. I like it. Brian Nichols.
Yes, sir. We're ready on that.
Brian Nichols. All right, this is cause number CR 20. So, you ready? CR 20-0292-173, the state of Texas versus Brian Keith Nichols. And this is set for trial docket status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Nichols.
We're ready.
All right, sir, is your name Brian Keith Nichols?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of cruelty to non-livestock animals?
Yes, sir.
And get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial
will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
And you can lower your hand. Mr. Nichols, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain, it could have certain negative immigration consequences. Do you understand?
Yes, sir.
And Mr. Nichols, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
Yes, sir.
Court finds he is competent. Mr. Nichols, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, Your Honor.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you have an agreement with the state whereby they would agree that you'd be prosecuted as a Class A misdemeanor, which is a lesser included on a lesser included offense of that which is charged in the indictment. A Class A misdemeanor carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, the state recommends that the court reduce this to a Class A misdemeanor of cruelty to non-livestock animals. Punish Mr. Nichols to 1 day in the county jail with time credit for 1 day, to include attorney's fees of $750 and court costs of $290.
Your Honor, there are still attorney fees. They probably forgot to correct it on her paperwork. I do believe the court's paperwork is accurate. It shows no.
It doesn't show any attorneys.
Because I'm retained.
It's okay. All right, Mr. Nichols, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Stevens?
Yes.
Mr. Nichols, you told me you could read and write the English language a few minutes ago. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of Mr. Stevens?
Yes, sir.
And did you sign it?
Yes, sir.
The next document I'm going to go over with you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages with Mr. Stevens?
Yes, sir.
Did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with me?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, that Class A misdemeanor of cruelty to non-livestock animals? Are you guilty or not guilty?
Guilty, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
State offers Exhibit 1, a copy of the offense report, and Exhibit 2, the initial inventory report.
No objection.
Admitted.
State rest in place.
Rest and close as well.
All right, Mr. Nichols, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that Class A misdemeanor, the lesser included of that which is charged in the indictment. The court will follow the plea bargain, sentences you to 1 day in the Henderson County Jail with credit for 1 day and orders you to pay your fine and court costs. And last thing, Mr. Nichols, did you review the judgment of conviction in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. Good luck to you. You need to see Mr. Halbert to your right.
Yes, sir.
Your Honor, if I can just have just a few minutes.
Yeah.
We'll have this separate. Right with Mr. Gleason, I think we were halfway through that one, and then we reached an agreement to proceed under the third degree lesser.
It might just be cleaner if I do it again. Ready, Mr. Stevens? I've got Gleason.
You got it, yes, we're
Yeah.
ready there.
Mr. Gleason, come on back up. I'm gonna start all over again. I think it's cleaner that way.
Yes, sir.
All right. Ms. Pace, I'm just gonna start all over and make it cleaner. All right, this is cause number CR 20-0280-392. The state of Texas versus Keith Leon Gleason. And let's see, this was set for trial docket status. Is that correct?
Yes, sir.
However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Gleason,
We're ready.
Mr. Gleason, we're going to do this again, okay?
Yes, sir.
Is your name Keith Leon Gleason?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the second degree felony offense of assault family violence?
Yes, sir.
I get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Gleason, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Gleason, have you ever been treated for any mental health or emotional issues? And I believe you told me in another hearing that you were prescribed Prozac. Is that correct?
Yes, sir.
But are you taking it as prescribed?
Yes, sir.
And do you understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds he is competent. Mr. Gleason, I know you were already arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a second degree felony. A second degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
However, it's my understanding that you have this deal worked out with the state whereby they would request the court to allow you to plead to a third degree felony, which is a lesser included of that which is charged in the indictment of assault family violence. A third degree felony carries a punishment range of not less than 2 years, nor more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
Your Honor, the state recommends that the court reduce this to a third degree felony, which is a lesser included. It's assault family violence by impeding breath. We recommend 2 years deferred adjudication with 77 days credit as of today's date, $750 in attorney's fees, $290 crime stoppers fee, drug testing, GED within 24 months, 80 hours of community service, a substance abuse evaluation, anger management class, and to schedule a mental health evaluation through the Andrews Center within 30 days and follow the recommended treatment.
And is the complaining witness on board with the plea bargain?
Yes, Your Honor.
All right. And Mr. Gleason, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Stevens, is that your understanding?
It is, Your Honor.
Mr. Gleason, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both front and back and sign the front and back with Mr. Stevens?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Stevens?
Yes.
And did you sign that second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Stevens? Well, if you read and went over those with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to waive your right to a jury trial and enter into this plea bargain? Then I'll ask you, sir, how do you plead to that third-degree felony offense, a lesser included of that which is charged in the indictment of assault family violence? Are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? I'll hear the evidence.
State offers Exhibit 1, a copy of the offense report, and Exhibit 2, the initial inventory report.
No objection.
Admitted.
State rests and close.
Your Honor, we would rest. Just for the record, I'd gone over the condition that he is to meet with the Andrews Center. He
Right.
had informed me that he had previously attempted to contact the Andrews Center, but they would not see him unless he was officially diagnosed, which led him to go see a regular doctor who prescribed him the Prozac. I told him with this court order and the help of probation, I'm assuming they can make some phone calls to the Andrews Center to get him in. I just want to make sure that he understands and that the court's aware that he has attempted in the past, but I don't know if
Sure.
because of COVID or the circumstances, they were denying him an appointment.
Okay.
Okay, we're good.
You understand that, Mr. Gleason? The probation department can refer you.
Yes, sir.
Okay. All right, then both sides rest and close.
Yes, Your Honor.
Yes, sir.
All right, Mr. Gleason, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense, the lesser included of that which is charged in indictment.
Your Honor, I apologize. It's a deferred probation, so defer finding a guilty.
Oh, it is.
You stated would find him guilty.
I retract that. Thank you. It's been a long day. Mr. Gleason, the court has enough evidence to find you guilty. However, the court will defer making any finding, places you on 2 years of community supervision. You do have 77 days credit as to any sentence you may eventually have to serve, and orders you to pay your attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision, to include the scheduling the mental health evaluation, which probation will help you with. And sir, have you ever been on probation? Do you know what can happen to you if you violate this probation?
Yes.
What can happen?
Go to prison.
For how long?
10 years.
That's right. If you violate any term or condition of this community supervision, a motion can be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if at a hearing, the court found that you violated at least or even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. You understand?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation. All right, who we got?
Passmore, Your Honor.
Is that the last, is that the last
Yes,
one? We
that
got another
should be the last.
Mr. Passmore, come on up. All righty, this is cause number CR 20-0668-392, State of Texas versus Eric Passmore. And this was originally set for discovery status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Passmore,
We're ready.
sir, is your name Eric Passmore?
Yes.
The same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance.
Yes.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Passmore, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, you can have certain negative immigration consequences. Do you understand that? Mr. Passmore, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on here today?
Yes.
Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds that he is competent. Mr. Passmore, I know that you've been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge?
Yes.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 2 years. I'm sorry, not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment? In the plea bargain?
Your Honor, the state's going to go forward under 1244A.
Okay, well, then I'll also tell you, Mr. Passmore, it's my understanding that in exchange for your plea bargain, the state's willing to prosecute you, which is willing to have you punished as a Class A misdemeanor, which carries a punishment range of up to 1 year in the county jail and a fine up to $4,000. Do you understand that range of punishment?
Yes.
Right. Sorry, thank you.
The agreement is for 100 days county jail under 1244A with credit for 104 days, plus attorney's fees, court cost, and 180 restitution to DPS. The state will take into consideration a filed case with a 1245 letter from the county attorney's office, 2020-0040 CCL2, and an unfiled possession of controlled substance penalty group 3, which would be a Class A misdemeanor.
Right. Is that your understanding of the plea bargain, Mr. Passmore?
Yes.
Is that your understanding, Mr. Stevens?
It is, Your Honor.
Mr. Passmore, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Stevens?
Yes.
Did you sign the front and the back?
Yes.
Do you have any questions about it?
No.
The next document that I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those?
Yes.
And did you sign the second one?
Yes.
Do you have any questions about it?
No.
Do you have any questions about any of the documents you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to enter into this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance, which would be punished as a Class A misdemeanor under 1244 of our penal code? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the
Thanks,
evidence.
Judge. State offers in the evidence states 1, states 2, and states 3. States 1 is the offense report. States 2 is Morton discovery compliance, and states 3 is the lab report.
No objection.
Admitted.
Nothing further. Rest in closing.
Rest in close as well.
All right, Mr. Passmore, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court will follow the plea bargain, sentences you under 1244 of our penal code as a Class A misdemeanor to 100 days in the Henderson County Jail with credit for 104 and orders you to pay your attorney's fees, court costs, and lab fee. And a couple more things before you go, Mr. Passmore. Did you get an opportunity to review the judgment of conviction in your case?
Yes.
Was your name, the charge, and the time credit correct? All right, sir. And finally, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. Okay, sir?
Yes.
All right, sir. Good luck to you. You need to see Mr. Halbert to your right. How many proofs did we do? That's pretty good. Afternoon.
Your Honor, may I be excused?
Yeah, appreciate you hanging out with us today. You've been here all day.
Okay.